Good afternoon, ladies and gentlemen. This is the Subcommittee on Rules on Lawsuit Reform. My name is Rob Leverett, and I'm chairing the committee, so I'll be conducting the proceeding today, or at least presiding. We've got quite a few people signed up to speak today. We're focusing on the last two substantive sections of Senate Bill 68, and I've got 18 people signed up to oppose and about 8 signed up in support. So to avoid, and I also do want to allow questions by members of the committee, so to avoid this going on quite as long as we did last night, I'd like to limit each of you to about 3 minutes for your testimony. I know that's fairly short, but just given the number of people we have to speak today, I think we need to impose that so we don't stay here forever. So we'll get started in just a second. I'm going to recognize Chairman Parrish and ask him to say a prayer for us before we get started.
Thank you, Mr. Chairman. Let us bow. Heavenly Father, we thank you for this day. We thank you for the opportunity of us to gather here as we discuss important issues to everyone in this state. We'd ask for your guidance and directions as we move forward. Help us all to do better. Amen.
All right. Representative Evans, did you wish to be recognized?
Thank you, Mr. Chairman. Just wanted to ask you to clarify for the folks that have joined us today that, just like yesterday, we're focusing on certain sections, but we'll hear anything folks want to tell us,
Correct.
right?
Correct.
Thank you.
All right, so let's go ahead and get started. I'm going to allow those in opposition to go first again. The first person who signed in is Kenneth Basile. Am I pronouncing the last name correctly? Yep. Is it Curavella? You'll be next, sir, if you want to be just your own deck. All right.
All right. Good afternoon. I want to thank you all for the opportunity to get up here and speak on behalf of myself, my colleagues. I began practicing as a chiropractor originally 25 years ago and currently serve as Chief Financial Officer for a medical practice management company that oversees the daily operations of a large orthopedic group with nearly 100 providers covering 18 locations throughout Metro Atlanta and further parts as far south as Macon. Yep. Gotcha. So I share this background to emphasize that I see firsthand the challenges Georgians face on a daily basis seeking out health care for their injuries. Senator Kennedy has made it very clear that Section 7C aims to promote transparency in medical billing so that if a plaintiff uses their health insurance, whether it be private or public, to cover their medical bills, the jury should be informed about those payments. At first glance, this seems simple and straightforward. The problem arises because I believe the current language of Senate Bill 68 extends beyond what Senator Kennedy's original intent was. Specifically, it reads, regardless of whether that health insurance has been used, is used, or will be used to satisfy such charges. This language, if left unchanged, could lead to significant and unintended consequences. Let me explain why this is problematic. After an accident, many injured individuals may choose not to use their insurance. There are various reasons for this: high deductibles and copays, the need for out-of-network specialists who don't accept their insurance, or simply the inability to find in-network providers willing to see them. In many cases, especially individuals with public insurance, they face significant difficulty finding providers who will even accept them for care after an accident. Because of these barriers, patients will exercise their federal right under HIPAA to not file with their insurance carrier. Instead, they choose to seek treatment under what's called a letter of protection, which allows them to receive care without upfront payment, with reimbursements coming later through a settlement from the at-fault insurance party. This process often takes years. If it passes with the current language, it could force patients to disclose information about their insurance, even if they consciously choose not to. This not only infringes on their federal right to privacy, but also raises the question, how could the actual payments made by insurance carriers be accurately determined if no claim was ever actually filed? This will disproportionately impact Georgians' most vulnerable population. That includes the low-income patients on Medicaid, the elderly, minorities who often rely on Medicaid benefits, children on peach care, veterans with their TRICARE, and disabled individuals that are utilizing Medicare as their primary source. These patients will likely find it more difficult to access medical care, as providers will no longer be willing to see them under the financial constraints, and they'll be left with no place to go to seek care for their musculoskeletal injuries and such, but area hospitals. And I don't think area emergency rooms can go ahead and tolerate that burden that will be inflicted upon them. You know,
If you'll go ahead and close for me.
Yep. Simple proposed revision to the language, striking the regardless clause. I think this will ensure that the actual payments are recognized, and it ensures transparency in billing without compromising the fairness and access to health care for Georgians. You know, in final conclusion, this revision, I believe, will preserve the integrity of Georgia's longstanding commitment to putting patients first and protecting their right to make informed decisions about their health care. This new legislation should not strip these rights away, you know, in an effort to go ahead and achieve civil litigation. I thank you for your time.
Thank you, sir. Anyone have any questions for this witness? I don't see any questions. Thank you very much for your testimony. We appreciate it. Curvilla? And then Dr. Robert Allen, you're on deck. All right, when you're ready, sir, go ahead.
Thank you, Chairman. Thank you, committee members, for holding this hearing. My name is John Curvilla. Can everyone hear me okay? Okay. Okay, thank you. Much better. All right, I had this great speech typed up, but considering that we only have 3 minutes, let me just touch on the highlights. Okay. All right, so I've been practicing law for over 25 years, and my practice includes plaintiff's work, it includes business litigation, some subrogation work, and believe it or not, some defense work. And so currently, I see the practice of law from all angles, and considering this statute or this bill proposed by the Senate that we are debating right now, considering this bill from all angles, it's not a good bill for Georgia. Couple of the highlights. One, the reason offered for this bill is that it will reduce insurance premiums. However, this bill as currently written interferes with the workers' compensation subrogation lien. Part of my practice, when money is pulled into an insurance companies use that money to offset the loss. However, the way Section 7 is currently drafted, collateral source is admissible in a personal injury action. Workers' compensation benefits are admissible in a personal injury action, and the way that affects recovery on the workers' compensation subrogation lien is a jury is going to be much less likely to award workers' compensation benefits as part of the plaintiff's damages, and if that's the case, then the workers' compensation insurance company is not going to have any remedy in trying to enforce its subrogation lien in the personal injury recovery. Again, unintended effect of the bill. But it is something that will happen, and that will cause insurance premiums to go up, not down. Further, because of the admission of collateral source, juries will be much less likely to award the full amount of the hospital's bill. What that means is that if the plaintiff does not recover the full amount of the hospital's bill, the hospital will end up not recovering as much of the bill. We don't want that here in Georgia. We want hospitals, particularly rural hospitals, to recover as much of the bill as they possibly can. And this will really affect settlement discussions because when the plaintiff engages in settlement discussions with a hospital, what they're going to look at is not the full amount of the hospital's bill, but the amount that insurance will pay on the bill. And so if the hospital's bill is $100,000 and the insurance contracted rate is $5,000, the plaintiff is going to say, you know what, hospital, you're only going to get $5,000 at trial. I'll give you $3,500. How is that good for hospitals? It's not. So the way that language is currently drafted is not good for Georgians. And I had a lot more to go over, but I will cut it short and just tell you a little story about one of the businesses I represent. I represent a trucking company, okay? And this is an example of how the bill as currently written is not going to protect businesses here in Georgia. Currently, the way insurance defense works is the insurance company hires an attorney to go ahead and defend the interests of the insurance company. In this case, will hire an attorney to defend the interests of the insured. In this case, the insured was a trucking company, my client, and it involved a death claim. My client had a lot of very good defenses to the case. Okay, I'm running out of time here, so I'll be quick. We found out that the plaintiff was under the influence of alcohol at the time of the injury, 0.06 blood alcohol level, and the plaintiff was cited at the scene of the accident, but the insurance company, at the advice of the insurance defense attorney, went ahead and tendered $2 million in policy limits over the insured's objection. What we need to do is give businesses and insureds some control over how the defense of the case is handled, and as a result of the tendering of the $2 million in policy limits, my client almost went out of business due to the increase in rates. But the way the bill is currently drafted, that does not address this problem. That's all I have for now. Thank you.
Thank you very much. Yes, Chairman.
Thank you, Mr. Chairman. Thank you for your work in bringing up both sides of the defense as well as plaintiff work. You mentioned, though, that the hospitals would get less money. So if the hospital bill is, I think maybe in the example we had, $100,000, the insurance maximum allowable is $25,000. The patient paid $5,000 out of pocket. The insurance paid the other $20,000.
Right.
Are you saying that after the trial is over, how often does the attorney group go back and give the other $75,000 to the hospital? Is that something you do all the time, or just rarely, or what?
Well, where the verdict,
Because you said it hurts the hospitals. So
where it's a special verdict and the damages are
damages,
allocated by the jury, and let's say $100,000 is allocated to the hospital or the medical bills, then the hospital can go ahead and say, okay, plaintiff, you recovered the $100,000, you need to pay back, the $75,000 to the hospital, the $20,000 to and the $20,000 to the
So that's something
company.
you do regularly, is to pay the hospital the
That's
rest of
something that
their
the Court of
amount
Appeal-
over what insurance covered? Between that and their list price?
That's something that would be much more likely to happen if the plaintiff recovered the full amount of the hospital bill or close to the full amount of the hospital bill in the
Well,
jury
right now,
verdict.
that's the only number the jury's told, right? For
Excuse me?
special damage. Right now, the only number the jury is told for special damages is the list price today.
Correct. That's my understanding. And collateral source is inadmissible.
And so you're saying that you always go and pay the amount over what insurance allowed up to the list price after the verdict, if you win the verdict?
My well, it's all negotiated at the end of the day, but my understanding is that the hospital has a much stronger bargaining position if the plaintiff recovers more of the hospital bill than less, as opposed to less.
Have you ever paid the whole amount, the full amount to the hospital?
Well, I can tell you, when I represented insurance companies, we have recovered the full amount.
But
We
you're
have
not.
recovered the full amount of the lien. I don't represent hospitals, but
Okay.
but that is a flaw in the bill, and I do think I do think that it just makes sense that the hospitals would recover more of their bill when the plaintiff recovers more of the bill.
Maybe they can tell us later. Thank you. The hospitals. Thank you.
Thank you, sir. You don't have any further questions. We appreciate you coming this afternoon.
Thank you.
Thank you so much. Dr. Allen? And next up is Gordon Terry, if you want to be ready to spring up here. All right, Doctor, go ahead.
Hello, everyone. I appreciate the opportunity to speak today. I will be brief. I am an audiologist, and I work in a multi-specialty clinic where we see and treat mild traumatic brain injury. We are, as far as we know, one of the only groups in the Southeast that does this in the manner that we do. Obviously, as part of what we do with our business, we see motor vehicle accidents and other legal cases. For us as a very, very small business, less than 20 individuals in our practice, we cannot wait the time that it takes to have medical liens settle. On average, it's 18 to 24 months from what we've seen and been told. I cannot support the staff to be able to keep those cases in mind and have someone dedicated to managing that case. I wish I had the money to be able to do that out of the gate, but I can't. So we use funding. We use collateral source to be able to keep our lights on, to be able to keep treating Georgians, and to offer the highest level of care that we can. I also believe that with collateral source and the ability to have funding in Georgia, it allows me to be impartial. It allows me as a provider to do my job and have zero care how a case settles. In my opinion, with medical liens, if I have to hold on to a medical lien, there is always going to be some concern that I have done my job differently to make sure that a case settles so that I can actually get paid for my work that is done. As a practice, we began, actually today is our 4-year anniversary of when we opened our doors. It took us 19 months to get credentialed with medical insurances. We have to have a location, we have to have providers, and we have to be able to see patients. That was a long time, and we used collateral source, we used funding to be able to see these individuals while we got our credentialing taken care of and keep the lights on. And at this point, we are happy to see all patients, regardless of how the injury occurred. We just want to be able to take care of them, but we also want to be able to keep our lights on so we can continue to do the job that we have been doing.
Thank you. I don't see that you have any questions, but I know you're very busy and appreciate your time. So
I appreciate the opportunity. Thank you.
thank you. Gordon Terry, and is it Chevin Polydor is next after Mr. Terry? All right, Ms. Terry, when you're ready.
Yeah, good afternoon, Chairman, members of committee. My name is Gordon Terry, and I'm the Chief Executive Officer of Integrity Spine and Orthopedics in Jacksonville, Florida. I'm also a UGA grad. Had the privilege of playing for the Dogs in the late 70s. Was team captain of the 79 Dogs under Coach Dooley. So why am I here? I've seen this show. 2 years ago in Florida, we went through the same thing that you guys are going through with Senate Bill 68. What was intended was lower insurance premiums, lower legislation. What really happened 2 years later is lawsuits haven't decreased, insurance premiums continue to increase. It's been a complete nightmare and a disaster, quite frankly. The only winner was big insurance, who continues to raise their premiums. I see mine going up every year. Those that suffered the most were over 10 million underinsured and uninsured citizens of Florida who lost total access to health care. The reason why they lost access is because medical providers were limited on what they could be paid in personal injury cases. And so therefore, like us, we're out. It doesn't make financial sense for us to continue treating these patients. We'd love to, don't get me wrong. As a matter of fact, last week, Florida House Speaker Daniel Perez launched an investigation in potential deception by insurance companies. And I quote, he says, a couple of years ago, when this tort reform was coming around, the insurance industry came to the legislator and said, without sweeping reforms, companies could not compete in Florida. We have since learned of reports not disclosed to the legislator that may suggest some insurance companies were using accounting tricks to hide substantial profits while telling us they were in a crisis. Please don't get wrapped up in big insurance sales pitch. You can't limit physicians on what they get paid. Section 7, as drafted, will have a devastating impact on potential access to critical care and providers in Georgia who treat these patients. It forces medical providers to wait 1 to 2 years to get paid, if they get paid at all. They get paid typically at Medicare rates or some health insurance rates, and that just doesn't make financial sense for medical providers in Georgia. It's not sustainable, it's not financially viable for any physician. The impact to patients in Florida is lost access to specialized care. This is discrimination in its worst form. Here's what the resolution is real quick, and I'll wrap up. Please strike lines 359 through 375. I'm going to say that again. Strike lines 359 through 375 in its entirety. What this will do, it will allow providers to be paid a fair fee, and it will show the jury the true amount owed to satisfy the provider's bill for what the patient owes. That's the resolution to this Thank you very much.
Thank you, Doctor. I think your fellow member of the profession has a question for you.
Thank you for being here and the work that you guys do. I'm looking on there trying to find out where it actually tells a hospital or a healthcare provider how much they can and can't charge in this bill. Maybe Florida's was different, and I've heard of some other states that did put a limit of either Medicare plus 50% or some number, workman's comp rates or something. I don't see that we put that in here, and maybe I'm missing it.
No, the way I read your bill is that it allows the defense to talk to a jury and say to the jury, well, this patient who doesn't have health insurance, if they would have used health insurance, it would have paid X, Y, and Z. If. Well, they don't have health insurance, so there is no payment. There's no payment.
Well, don't they also get told the total bill amount too?
Sure. They
Okay.
absolutely get told the total bill amount. And I'll tell you that there's some in Florida, there's some in Georgia that take advantage of that. And there's laws against that, and those people need to be run out of town. I support that.
Thank you. No.
Thank you very much. We appreciate your testimony. Is this Ms. Polydor?
Yeah.
And Brandon Peak, if you'll be ready for the next witness. Go ahead, please.
All right. My name is Chevin Polydor. I'm the owner of Revive Orthopedics, and I'm here today to represent countless patients in Georgia who stand on the edge of a precipice caused by SB 68. And really what SB 68 changes is really there's a bait and switch that's going on here. Even when a patient never uses insurance, SB 68 forces the court to act as if they did, which can reduce their medical costs or the medical reimbursement to an artificially lower number than what they actually owe. So for example, let's say a patient has a $150,000 bill, did spinal fusion surgery in an outpatient surgery center like mine, and maybe they have some other ancillary treatment. So maybe Blue Cross would have paid $50,000 on it. Medicare or Medicaid doesn't cover that particular surgery in an outpatient surgery center, so they would have paid zero. So when you convert it to Medicare or Medicaid, it would be zeroed out. And then maybe the rest of the bills that they have, maybe that gets converted to maybe $2,000. So that's what the jury hears. If the jury picks that lower number, yes, you're right, Representative, that the full bill can still get presented. But now the jury has a $2,000 and $150,000. Which are they going to pick? If they pick the low number, then it puts that patient into a really bad state. People can come after their home, their property. But worse, what it also does is there are a lot of doctors will look at that and say, well, I'm not going to take that risk. So if spinal fusion surgery in my surgery center costs me, I got to pay for implants, I got to pay anesthesia, I have to pay this, that. Maybe people who have Medicare, Medicaid, I'm not even going to provide that service at all. People who have insurance, maybe on some of them I will, and if they have assets, if they don't get enough recovery, then their assets, people could go after their assets. So this could cause financial ruin for patients who do get seen, but it could also cause a lot of other patients who won't get seen. So I just did a quick survey of some other groups in town, and I came up, just in my limited survey, about 150,000 patients who will lose access to care. But the other people who do get care, we're exposing them to medical bankruptcy and other things if they do happen to have some assets. I have people who use letters of protection who are construction company owners, who are college professors, et cetera, who may have assets, and people could go after their assets. That's what this bill does. And so really, the other thing that I should mention is there are a lot of these people who are currently getting care who won't get care are going to fill up our hospitals. Grady, Arda Hospital is going to be overrun. So Senator Kennedy said in this bill that it fights fiction in the court, when he presented this bill, but it just replaces one fiction with another. A bill, he replaces, one fiction, which he says is the doctor's bill, with another fiction, which is what Medicaid would have paid when Medicaid wasn't used. There are lots of treatment that Medicaid doesn't cover. Somebody doesn't want to have shoulder surgery, PRP injection. What's Medicaid reimbursement for that? Zero. Chiropractic? Zero. All of those things will get zeroed out when this gets presented to a jury. And I did my own informal survey of doctors who provide this care. And not a single one of them said they'll provide it to Medicare or Medicaid patients. Chiropractors say they will not. So if this bill overtly said that we would take away care for, non-catastrophic care for Medicare, Medicaid patients, it would cause a political upheaval. So all I'm asking really is this. Let's not do covertly that which we would never dare do overtly, and let's preserve access to patient care. And that requires just a simple fix. Whatever is owed is what gets presented. Let's eliminate all the fiction, not just one fiction, and replace it with another.
Thank you, sir. And I'm assuming you're joining Dr. Gordon with the fix he was proposing? Is that what you're suggesting?
Yes, and I think the fix is really very simple. It's this, Senator Kennedy rightfully points out, but it's a little bored, that if a patient has a $100,000 bill, but $25,000 is what they owe Blue Cross, the $100,000 is fiction. They should be able to present fact. But when no insurance was used, he also wants to impose a new fiction, what insurance would have paid. But that's fiction. That's not what the patients owed. And for anybody who's ever been involved in collecting on this, a legal action to collect on what a patient actually owed. I've been involved in a case where a patient owed me money, they settled their case and decided to tell their attorney not to pay me. You go into court, it's extremely simple. The judge asked the patient, did you sign this that's saying that you were going to pay? Yes. Did you incur these bills? Yes. Did you pay these bills? No. Judgment for the plaintiff, easily. So you have a patient who owes $100,000, but may get reimbursed $2,000 for Medicaid or $25,000 for Blue Cross, and they still owe the difference. You're leaving them upside down. That is what this bill does, and it will result in two things. One is access to patient care. So there's no money to go after a patient who has Medicaid, so you're not going to provide that care. But other people, could be upside down. I brought a patient to the Senate named Betty, who had Ambetter insurance, and she got 8 years of treatment. She couldn't find anybody to take her Ambetter, and so she ended up using a third-party funding company and got 8 years of treatment. And even though she waited for 7 hours to testify, we asked her if she wanted to leave. She said, no, this is too important, and she didn't have any food or anything to eat. But she thought it was important because she would not have gotten that care. Under SB 68, she would be harmed. Senator Kennedy says nobody will be harmed. Well, actually brought a patient in a wheelchair to the Senate who would have been harmed by this bill as currently constructed. But the fix is very simple. If Betty owes how many ever hundreds of thousands, that's what gets presented. Don't present some fiction about Ambetter, which was never used. Why do we want to talk about eliminating fiction and introducing fiction at the same time? That's all we're saying.
Thank you, sir. I don't see you have any questions. Thank you for your testimony. Brandon Peak, and then Josh Carroll was next.
Good afternoon, Mr. Chairman,
Good afternoon.
members of the committee. My name's Brandon Peak. I'm a partner at Peak, Wooten, McDaniel, and Caldwell Law Firm in Columbus, Georgia. I'm here to speak in opposition of Section 8 of the SB 68, which is the portion of the bill that deals with mandatory bifurcation or trifurcation in all civil cases involving personal injury and wrongful death upon the election of a single party. Before addressing some of the practical problems with the bill, I think it's important to say this. Mandatory bifurcation or trifurcation in this bill only deals with personal injury and wrongful death cases. Doesn't deal with business tort cases, doesn't deal with commercial disputes, doesn't deal with land disputes. You're singling out a certain class of Georgia citizens, those who have been injured and the family of those who have been killed. If this was good public policy, it would apply to all such civil cases. There are some significant equal protection concerns with this portion of the bill that we believe may not pass constitutional muster. But there are a lot of other practical problems with the bill. First and foremost, it's unnecessary. Under Rule 42, right now, a trial judge can grant bifurcation or trifurcation upon a motion of a party if there's a good reason to do it. The only thing this bill would do is force trial judges to grant bifurcation or trifurcation when there's no good reason to do it. I'm glad Chairman Gunner is here. He's a trial judge, formal trial judge. He will tell you we have excellent trial judges in the state of Georgia. And one of the things that they are concerned about is saving citizens time and preventing duplicative testimony.
Y'all have heard some duplicative testimony in this committee. And what judges are focused on doing is ensuring that citizens' time is not wasted and you don't create unnecessary bureaucracy in trial. What this bill will do will strip the judge's discretion to run their own courtroom and force them to do what one party wants them to do because that party elects it. Third, this bill is going to inconvenience witnesses, which are your constituents, Georgia citizens. Take a garden variety car wreck case. I see the wreck occur. I see the person that's injured and go to their vehicle to ask how they're doing. And when I do that, I happen to smell, then I go to the other vehicle to check on the defendant as well and smell alcohol on their breath. Under this bill, if one party elects for bifurcation or trifurcation, that one Georgia citizen is going to have to testify 3 separate times in the same trial. Once about who ran the red light, once about the extent of the plaintiff's injuries, and another time about potential evidence relating to punitive damages. In a trial right now, that witness can testify in 15 or 20 minutes, go home, and be done with their life. So there are lots of other problems with this bill that I would like to address, but I would just finally ask that you consider what it does to both plaintiffs and defendants by forcing them also to testify multiple times. That's a traumatic experience, not only for plaintiffs, but also for defendants. Think about requiring a mother who has been in a wreck and lost her child who died in the back seat to come testify twice. Once about the wreck and another time about the effect that the loss of the child has had on that family in terms of damages. That's a very real reality of this bill. No trial judge with a heart, in my experience, would require that. But if it's mandated, that's exactly what's going to happen here.
Thank you. I think you've got a couple of questions. I did not check to see who came up first. I think Chair Lady Miller was first.
Thank you, Mr. Chairman, and thank you for your testimony today. I guess my question, and I think you touched on it a little bit, about singling out a class of Georgians to be treated differently under our code. As a lawyer who has practiced in various areas of the law, can you think of any justification for such a, I won't say egregious, but extreme overhaul of one area of the law without touching on the other areas? For example, jurors who show up for jury duty don't know what kind of case they're going to get. They may get a business litigation case, they may get a car accident case, they may get a capital homicide case. Why is a juror qualified to do and decide complex things in other areas, but somehow when it comes to car accidents, they are so confused, the judges don't know what to do, they don't know how to instruct the law, they can't manage their own courtroom. Can you just tell us your experience in that regard?
Yes, jurors are very smart, and before any testimony is presented to jurors, both the plaintiff and the defense have an opportunity to give an opening statement to tell them what the issues will be. The defense gets an opportunity to tell the jury before any evidence is presented, we're going to request a defense verdict because we didn't do anything wrong. And the jury thereafter views the evidence in light of that. After that, judges can also give a pre-charge to a jury, which says you're not to take into consideration anything with respect to damages unless and until you believe that the defendant has committed negligence. In business tort cases, those jurors would be able to hear evidence both about the tort that led to the damages and the damages that the business has suffered in the same case without unnecessary delay. Jurors are smart enough to understand that I'm not going to award damages unless I found liability. They do that all the time now. There are lots of defense verdicts in cases where people are very grievously injured. And that damages testimony, I think for non-lawyers, this is important. Damages testimony is often very brief. I mean, you're not going to put somebody up there for a long period of time to talk about the plaintiff's injuries or the loss. If you do that, the jury's going to punish you for what I call crossing the Maudlin line. So you know, the idea that this is going to save time and efficiency is just, it's a fallacy, but there's no good reason to treat them differently.
Thank you. Representative Evans.
Thank you, Mr. Chairman. Something I want to ask you about a concern I've been having with this bifurcation and see if it's a concern for you, and kind of, if it is, explain how we might deal with it. If we're going to bifurcate and we're going to have liability and then we're going to have damages, a simple view of the law is that you don't have liability unless you have a completed tort. And from law school, I learned from Professor Sintel, Section T, that inside lawyer joke, sorry everybody here who didn't go to the University of Georgia.
I'm glad
Law.
he's not here questioning me.
Yes, it would be hard. But you don't have a completed tort, so you don't have liability until you have damages. And if you can't talk about damages until the second trial, how do you ever get to liability in the first trial? Do you have any thoughts on that?
Well, I do, and I've been looking at this bill a lot, obviously, and if you look at lines 394 through 398, which is the first phase of this mandatory bifurcation and trifurcation, there's still a requirement that each defendant be at fault for the plaintiff's injuries or wrongful death. So you're still going to have to prove in phase one that the tort caused a specific plaintiff's injuries. So that evidence is going to have to come in that phase in order to prove that, you know, this specific tort caused this specific injuries. And then you're going to have to say, all right, everybody stop. Don't say the next thing, which is the effect of that. And we talk about doctors. For doctors' depositions, this is going to be a nightmare. I mean, we all try to take doctors' depositions outside of the courtroom so we don't have to compel them to come and testify. So we're going to have to ask the doctor first, in your professional opinion, did this particular tort cause the plaintiff injuries? And then you're going to have to stop and figure out how to present evidence next, which is what the effect of those injuries are moving forward. And so, you know, it makes absolutely no sense to do that when the same thing could be done logically in a short amount of time. And for non-lawyers, I also think it's important for them to understand, after every phase of this trial, there's going to have to be closing arguments, jury instructions, and deliberations, which all take significant amount of time. Then you're going to bring the jury back for 30 minutes for the same doctor to give, you know, 5 minutes of testimony and 2 more people to give testimony. It's just, it's entirely inefficient. And the entire problem could really be fixed by, in line 392, removing the words elect by written demand and replacing those with file a motion. If you got a good reason to bifurcate or trifurcate a trial, you can file a motion and the judge can rule on that.
All right, thank you. I think Dr. Newton had a question.
Thank you, Mr.
Thank you.
Chairman. Yes, on that, I mean, I guess that's the case right now, is you can ask and be turned down. Right, that you can ask for bifurcation and the judge can say no.
Correct.
This
Yeah,
bill
we
would
don't-
say if you request it, just like a voluntary dismissal we talked about in an earlier section of this, if you request a voluntary dismissal without prejudice, then the judge, I guess, has to do it. And you're saying that's what would happen in this case, is that if somebody requested bifurcation, the judge, after this law, if this law goes into effect, would be required.
They'd have to do it. Yeah, it's bureaucracy in the courtroom.
The 2 other things you mentioned, you did mention something about how you appreciate juries and how smart they are. I hope that applies to Section 7 of this bill, their ability to see the list price for services and the full price, paid in full amount that an insurance company or other arrangement might have gotten. That. So I appreciate that about juries. You did say, too, something about defense verdicts. Tell me, in the defense verdicts, if we had bifurcation, wouldn't the trial be a little shorter? I don't know how often a defense verdict happens. Is it half the time, 10%?
Well, in medical negligence cases, it's much more than that. It's something.
So all those cases would be shorter for the jury, for the judge, for the court, for the doctor, for everybody would be shorter, because you would never get to damages because nothing had been done wrong. Is that correct?
In theory, yes. In practice, no. Damages evidence is often very, very short because you're not going to want to put anybody through talking about that over and over again. I'm only here to talk about Section 8 of the bill and not Section 7 as it relates, because I only had 3 minutes. So I'll let somebody else address that question for you. But in practice, honestly, it's not going, it's going to, the difference, if you're trying to save time, the amount of de minimis time that may be saved if this bill is passed versus prolonging a ton of other trials if it's passed, you're going to be creating much more inefficiencies in the system. Trials are going to take much, much longer. There are going to be less cases that get to trial because the trials that do exist are going to take longer to get through.
I guess I don't quite understand if we don't even get to the damage phase, then there's really not a whole, the patient doesn't have to testify about damages, long-term, whatever, nothing really comes up, it seems like, if for all that time, and putting the patient through that, I say patient, but injured party.
For every one of those cases where you may save some time, there's going to be 20 other cases that are prolonged significantly, and the net effect is you're going to create much more inefficiency in the system. And I just, trust me on this, but please check and ask a trial judge, and I believe they'll tell you the same thing.
No, thank you.
Thank you, Mr. Chairman. And just, Mr. Peak, so that I'm clear, in your years of practicing, is there any other place in the law where we have such a distrust of judges and their ability to run their own courtroom as you understand it right now?
Not that I'm currently aware of, but that may be a better question for the judges, but not personally that I'm aware of. I mean, think, for instance, it's typical for witnesses to be taken out of turn. For instance, in a case where somebody has a death or a disability, or an expert has to get back to wherever they're from, the judge has the discretion to take that witness totally out of turn and allow them to testify earlier in the case. I mean, situations come up in life, and this is just removing the judge's ability to independently run his or her courtroom.
And typically, if you're talking about a business tort or complex business litigation, wouldn't the argument be stronger in those cases than in these cases, which are oftentimes, duty, injury, breach, damages, to do the same thing across the board in every single trial we have? Why would we, I guess, can you see the logic of why a judge who can preside over a complex RICO case, or a complex business dispute, or a complex business tort, can run his or her courtroom efficiently without 3 trials, but something magically happens to a judge when it comes down to an injured party that they can't do the same thing there? Can you think of any logic that would support that?
Not personally, and those cases are going to take longer to present the underlying liability, which, if you were going to be really interested in time saving, you'd be focused on those rather than the garden variety road wreck case that can be tried in a day or two.
Thank you, Mr. Chairman. Just really quick to follow up on Chairman Dr. Newton's question about any savings we're going to have when you have a defense verdict. I just want to make sure you agree with me. The ones that we are going to drag out, the ones where we are going to make people come back and talk twice and maybe 3 times, those are going to be the ones where the jury found fault with the defendant, and that we found that there was liability, there was a legitimate cause of action that led to damages. So those plaintiffs are going to be the ones that we're dragging in and making them prolong their life to get justice. Do you agree with that?
Correct. And the witnesses.
Yeah. Thank you.
All right, I see no further questions. Thank you very much for your testimony. Josh Carroll and Jason Branch, you're up next. Good afternoon, sir.
Good afternoon. Thank you for having us here. My name is Josh Carroll. I'm a lawyer in Macon, and I'm going to be talking to the committee about how the collateral source rule would be applied under Senate Bill 68. I'm going to give you a hypothetical to put this language into action, so I want you all to kind of listen along with this hypothetical. So let's assume that in January of 2023, my wife's T-boned by a drunk driver on her way from dropping our kids off at soccer practice. She's taken to the hospital in an ambulance. They run CT scans, discharge her with a concussion and some neck pain. And over the next 2 years, she gets just conservative treatment. She doesn't want to get a surgery, and ends up she has a herniated disc in her neck. Okay? In early 2025, so we're 2 years later, her surgeon tells her only remaining option is to have a surgery. She can't deal with the pain, so she schedules the surgery for the summer while the kids are out of school. In the meantime, her lawyer is preparing this case for trial because they feel that the drunk driver's auto insurer isn't handling the case properly. What I think we're losing in the process of considering this bill is that over the past 3 years, hypothetically, we've gotten our insurance through my law firm's plan, right? Through my law firm's self-funded ERISA plan. In 2023, her portion of the premiums, just her portion, is $6,708. 2024, her portion is $6,980. 2025, her portion is $8,002. So that's over $22,000 in premiums just for her portion from 2023, 2024, and 2025. Now, during that same time period, for my entire family, we have paid over $62,000 in health insurance premiums. $62,000 in health insurance premiums. And like I said, this is a hypothetical woman. Thank God this isn't my wife and that she wasn't the victim. But these premiums that we're paying are not hypothetical. They're real. These numbers are pulled directly from my firm's insurance statements. I have the privilege of doing that for the firm, which is so much fun, but I did have access to this information pretty easily. So what I want to show you, and I'm going to do this as quickly as I can, using my good friend Senator Kennedy's example. He's my neighbor in Macon. His prior example of $100,000 in medical charges for the services that my wife would have hypothetically received here. Let's look at a really realistic breakdown of those charges, how they're paid, what's written down, and how all this would be used in court under Senate Bill 68. With our health insurance, our per person deductible is $2,500 per year. So over 3 years, that's $7,500. That's the pink portion at the very bottom. That doesn't include copays or deductible or extra out-of-pocket max items. And I've seen what our insurance pays on larger bills, which is usually around 35 to 40% of the entire bill. So this green portion in the middle is what health insurance is actually paid for those services. And under federal law, because my plan is a federal ERISA plan, we have to pay that entire amount back straight to United Healthcare for those services. The last thing that I want to show you is that this top portion in blue here is what I've heard a lot of people refer to as phantom damages or trumped up damages. And that's just a misnomer, plain and simple. That $55,000 that's listed there is a contractual adjustment that I've paid for, okay? I've paid for that to have the right for United Healthcare to give me that rate, and that the hospitals and doctors I go to will charge me that rate and charge United Healthcare that rate. That's the benefit of the bargain that I get for the contract I've entered into. One person who's not a party to my contract is the drunk driver, right? But Senate Bill 68 would give the drunk driver who caused this wreck the benefit of my health insurance contract. The last thing that I'll say is this spot on the very far right here. This is an uninsured victim. That's the person who doesn't have any health insurance. Under Senate Bill 68, that person who may be an illegal immigrant, we're giving them more rights under this bill than people like my wife and I who pay our health insurance premiums and spend $62,000 over 3 years to have the right to have these prices. Thank you for your time.
Thank you, sir. I do see a question. I see two. All right, go ahead, Chairlady Miller.
I'm faster than Rep. Evans, apparently. Okay, so I just want to make sure I understand that because this is an important point in my mind. In the bar chart, so the so-called made-up or fake portion of the damages, which is the which we get because you and your wife are actually paying for that benefit. That's what you have bargained for as the person who is paying for health insurance, correct?
Yes, that's correct.
Okay.
That's the contractual write-down.
Correct. And so why should, and I guess this is your point, why should anybody else who didn't pay for that get that benefit? Why is it that a tortfeasor or a person who has done harm get the benefit of you and your wife's responsible behavior and payment for it.
Yeah, so that's sort of why folks in our camp refer to that as premium theft, right? We're allowing the person who committed the wrong to get the benefit of the bargain in the contract. The purpose of the collateral source rule when it was instituted was if there's going to be a windfall, the windfall shouldn't go to the wrongdoer, right? It shouldn't go to the person who caused the harm. And that's what we're losing sight of as we discuss essentially abrogating the collateral source rule in this context. We still don't allow the jury to hear how much auto insurance or how much liability insurance the defense has. Maybe if we did that, everybody would be satisfied. But you know, that's not the conversation we're having.
Thank you, Representative Evans.
Thank you, Mr. Chairman. Thank you for being here. 2 quick points I want to follow up on. First, just insurance is a little confusing to me. I think I understand the charts. Under your example, you and your family have paid about $62,000, like you said, for the benefit of insurance. You paid the premiums. And under the way that Senate Bill 68 is written, you have no chance to get that back.
No chance to get that back. I think there was one draft that had some type of premium reimbursement provisions that some states have. I think including even Alabama, they have a premium reimbursement provision in theirs. I'm not saying we should model our laws after Alabama, but that is something some states do, is they do allow you to recoup how much you have paid out over time.
And then the second question I have is, and you started to allude to it there at the end, it is currently the law and will remain the law, even if Senate Bill 68 passes in its current form, that the jury, while now they're going to get to know that a plaintiff has insurance, they're still not going to get to know that the defendant, doctor or person that caused the wreck, that they have insurance. Is that accurate? And can you tell me your thoughts on the fairness of that?
I mean, I think if you're allowing the victim's insurance to come in, then certainly the defendant's insurance should come in. That's part of the reason that a similar bill to this was struck down in 1992 as unconstitutional. It reads very similar to the language that we have in this bill. And it was a question of, well, it's not fair to one to be able to put in the insurance. On the other side, the jury just sits there and guesses whether this person that's sitting in the defendant's chair has anybody there that's going to pay for what they owe, right? So, yeah, I guess I don't think that's very fair.
Thank you, Mr. Chairman. I guess I don't quite understand one thing, because the jury, my understanding under Senate Bill 68, they would see the numbers you just described, which is what your out-of-pocket was, what insurance paid, and what the total amount was. And I think we've talked about, I think it's what the enlightened conscience of the jury. Aren't they able to look at that? And there's no prohibition that I know of, I can't find it, on awarding you the 100% if the jury sees fit to do that. All we've done is given them information. We've heard about how smart the juries are, and they got wise defense lawyers and plaintiff lawyers helping them. Can't they decide somewhere in between there if they want? Can't they decide to give the whole amount if your attorney makes a good case? Aren't they still free under 68?
Well, my question to that would be what in the language of this bill allows my attorney to make a good case for that, right? My attorney is not allowed by the language in that statute to argue that I should get the premiums I've paid, that the defendant should have to come back and reimburse me for those. The other thing is that the defense lawyer is going to stand there and say, this is all they're out of pocket. This is all they're out of pocket. This is all that you should give them. Don't give them this amount. And if you're sitting there as the juror, what are you going to do, right? You're going to say, well, there's no way for me to pay their health insurance premiums back to them, right? So I'm just going to give them what's there, what's out of pocket, because that's the argument that the defense is going to make. Everybody thinks that the plaintiff's lawyers are real clever and come up with these clever tactics. The insurance defense lawyers do that just as much. They come up with clever ways to, pardon me, but screw people out of money. So it just depends on what the jury buys that day. Yeah, but the bill doesn't give me the tools I need to explain to the jury why that margin's there. Why is it there?
Is there something in the bill that prohibits you from saying that to the jury?
The collateral source rule that's still in the evidentiary code. I can't talk about the fact there's health insurance. The way the bill reads is we can put in the amount that's billed, and the defense can put in the amount that was actually paid. There's no provision in there that says that there could be a breakdown of how all that's handled. Like, in other words, that it was United Healthcare, or that it was MedPay from the Geico auto insurance. All this does, the way that this bill reads, all it allows is for us to put in the amount that's billed and then the charges necessary to satisfy that charge. So the rest of that green part right there, is the blue part, that's all lost in the shuffle. It's up to the jury's translation at that point. Because, and that's by design, okay? I mean, that's just, the purpose of this is to save auto insurers money. I mean, that's it. They're the ones that are going to benefit from that, not the people of Georgia. Thank you.
Jason Branch and Dan Snipes, you're on deck.
Good afternoon, Mr. Chairman and distinguished members of this committee. I appreciate the opportunity to be before you today and speak. I'm going to piggyback a little bit on what Mr. Carroll just talked about in Section 7. And for me, the conversation was started, and for me, the fundamental question presented by this bill is this. Is it fair for the defendant, tortfeasor, wrongdoer, the person that causes an injury to somebody, is it fair for them to get the benefit of the innocent victim's insurance coverage that the innocent victim has dutifully paid premiums for month after month, year after year? Is it fair to give the benefit to the wrongdoer that caused the injury in the first place? And I think the answer to that question is a resounding no. I don't think that's fair, and I don't think it makes sense. And for the last 150 years in the state of Georgia, Georgia law has said that is not fair, that does not make sense. In the majority of the states around us, North Carolina, South Carolina, Tennessee, Mississippi, they have similar laws that we have now in existence, and they say, no, that is not fair. That's not the way it should be. Let me give you just a brief example to put this into context without the convoluted medical insurance. If I get in a wreck driving home to Columbus this afternoon and a drunk driver crosses the center line and hits me, and a trial of the case of trying to establish what's the full value of the life of Jason Branch, the jury comes back and says it's $2 million. Well, let's also say I'm a responsible, hopefully, father of 3 children, and for my wife, I've gone out and gotten life insurance for myself and say it's $1 million. So the jury takes the value of my life, assigns a value of $2 million. The question is, should a defendant be able to come into that case and say, well, there's the loss, it's $2 million. Now, the plaintiff went out and bought insurance for his life, and Prudential paid $1 million, so your actual loss is only $1 million, and so therefore the drunk driver should only pay $1 million. Does anybody here think that's fair? I don't think so. I think the answer would be it's a resounding no. But that very same principle applies to any form of insurance that an injured person goes out to procure for themselves, to be responsible, to protect and provide for their family in the event something happens to them, whether it be life insurance, disability insurance, accidental insurance, burial or funeral expense insurance, or in this case, health insurance. And what this bill does is allow a defendant wrongdoer to get the benefit of an injured party's health insurance that he or she has paid a lot of money for the protection of themselves and their family, and it allows them to do it for free. Another problem with this bill, just briefly, is we start treating plaintiffs differently based on the insurance that they provide. And most disturbingly and ironically, the person who's punished the most is the most responsible Georgian that goes out, like Mr. Carroll, and provides that plan for himself. The people who don't have insurance or choose not to have insurance are treated the best, which is a perverse incentive. We ought to be encouraging people to have health care, one, for themselves, but two, to take that burden off the government and the state for having to fund those. The last thing, and I'll just say this quickly, and it's not talked about, in the example that you get when you have $25,000 of actual post my benefit of my insurance reduction, $25,000, what isn't talked about is, well, what did it take to get there? And what part of what it took to get there is hiring an attorney to fight an insurance company to get them to award that in the first place. So if it's $25,000 we're talking about, they're going to pay their attorney a third, so you're going to reduce that by $8,333. So that's left. What are you going to do next? Like Mr. Carroll explained, the plaintiff is going to pay that $25,000 back to United Healthcare. So where are they? Now they're in the hole, a negative $8,000. And then you take the premiums they've paid that Mr. Carroll's explained about for 1 year, 2 year, 3 years, you're going to they're out that. So they're in the hole. So now you're taking an injured victim who is minding their own business, who's injured by the wrongful conduct of somebody else. You're going to say, go to court, get medical bills, and then they're going to end up upside down and in the hole. There is no windfall for the plaintiff in that situation. There is no incentive for them to even pursue medical bills. The only person getting the windfall is the negligent wrongdoer who caused the whole injury in the first place. Sorry for going over a little bit.
No problem. Thank you, sir. We appreciate your testimony. I don't see that you have any questions. Mr. Snipes, and is it Denise Hoying? You're up next. When you're ready, sir.
Good afternoon, Mr. Chairman, and I'm Dan Snipes. I'm an attorney in Statesboro, Georgia. I was president of Georgia Trial Lawyers Association 5 years ago. I want to start by thanking the committee. By my count, this is about the 11th hour of testimony that y'all have heard on this bill, and on behalf of GTLA, we appreciate the seriousness with which the House has addressed Senate Bill 68. One thing that's been clear from the testimony, there's two things that are very clear to me from the testimony I've heard of these 11 hours. First of all, there's many businesses that are named as defendants in cases that are not very meritorious, and those businesses have legitimate concerns and they need changes. And likewise, this testimony has shown that there's many people that have been harmed by the acts or the inactions of others, and those persons have meritorious claims and they deserve access to the courts. Georgia's civil justice system and the justice administered by our judges and our juries is fair and balanced. And that's borne out by the fact that more businesses are locating in Georgia than ever in our history. And if our court system was inherently out of whack, we would not have the massive economic development that we've seen since Governor Kemp's been governor. He's done a great job. One other thing, and Dax Lopez, who's a retired state court judge in DeKalb County, came and testified, and I'm sure Chairman Gunner would tell you the same thing. Our juries get it right almost all the time. The same people that elect the members of this General Assembly serve on juries. And just as our citizens make good decisions at the ballot box, they make good decisions when they go into the jury room. Now, that doesn't mean, though, that our court system cannot be improved. GTLA remains committed to punish persons and lawyers that bring frivolous lawsuits or who try to manipulate the system by using inflated medical bills. But likewise, as we just talked about, when a citizen does the right thing and purchases insurance, they shouldn't be treated differently than somebody who doesn't purchase insurance when they present medical evidence. Businesses and property owners deserve clarity for when they're responsible for injuries for people that they invite on their premises. But likewise, these same businesses deserve to be held accountable when they're aware of a risk of harm and they fail to take reasonable steps to protect their invitees or customers from those risks of harms. SB 68 is going to change how injured parties bring claims. It's going to change the evidence they bring in support of those claims and how lawyers present these claims. SB 68 is not going to change or lower insurance premiums for any type of coverage, whether it's automobile, private or commercial general liability, or some type of property insurance. What they try to use is the word stabilize. But I challenge you, do your own research. Google why are insurance premiums high or rising in Georgia? And you're going to find out it's inflation, it's storm damage, it's crime. Nowhere is someone going to say that the insurance premium crisis in Georgia is a result of litigation. And then they're going to try to say, well, look at what Florida's done. Well, Florida's one of the few states in the Southeast that has significantly higher insurance than Georgia does. And I think you'll hear later, Georgia has more accidents than every state that touches us as it relates to automobile insurance. Florida's insurance rates continue to go up. If they stabilize at all, it's just been recently, and it's not the result just of anything that happened in the court system. GTLA remains committed to working within the framework of SB 68. within each section of SB 58. I've got great respect for Governor Kemp. I have great respect for President Pro Tem Kennedy. Many of the people that have testified in favor of this bill are friends of mine. They will remain friends of mine. We may have differences of opinion as to about what's best for our court system, but we are committed to work within this system and within the legislative process to try to find common ground. And that's good for both sides of this, and that's what we want, and we're going to continue to work on that.
Thank you so much. I'd say we have one or two questions. Dr. Newton, if you want to go ahead.
Thank you, Chairman. Just kind of a question I think I may have asked the earlier judge too the other day. Do you believe that juries can understand, especially with the assistance of a skilled attorney and a judge, they can understand two numbers when given information about medical bills? Do you believe that when they decide damages for an injured party, do you believe they can be given information and that with assistance of counsel can understand and make an informed judge? Are they that smart?
I certainly think jurors are smart, but I think your question's based on a faulty premise. And the premise gets into who should get the benefit of the health insurance that the injured party paid for. Who should get the benefit of the contract when there's a contractual adjustment on the bill? And should the injured party get the benefit of that, or should the party that caused the harm? And we believe that the party that caused the harm should not be the one to benefit from that.
If you can, is there a line you can get back with me on in this bill that prohibits attorney from saying exactly what you just said? Because I can't find a prohibition on you making a very articulate argument, or the earlier one, in front of a jury. And once again, it's an enlightened jury. I hope they can understand. You're making a very profound case.
The collateral source rule, as applied, has been the common law in Georgia since the 1800s. And any time a legislative body starts to overturn something that's worked for the citizens of Georgia for now going well over 150 years, I think they have to be very concerned about what are the unintended consequences of overturning the law that has served our citizens so well. And I don't know exactly how this plays out, but I'll throw back to this. In 2005, the last time the governor of the state of Georgia addressed major changes to civil justice, of what's left from that is apportionment of damages. And I would tell you that the changes of elimination of joint and several liability to create apportionment is a big reason why we're having to address negligent security today. And that is an unintended consequence of what this body did in 2005. Likewise, the change 9/11/68 is something that was created to deal with people bringing cases in bad faith and to punish them. But the reason section, let me get it right, 5 is in the bill is because plaintiffs' lawyers are using 9/11/68 to the detriment of defendants. And that's another unintended consequence of what happened in 2005. So I would caution you to change established Georgia law that works, because you don't know what you're unleashing.
You follow? No. Okay. All right, Chair Lady Miller, I think you were first on the board.
Thank you, Mr. Chairman. Thank you, Mr. Snipes. Just a quick question. So you talked about how long the collateral source doctrine has been a part of our jurisprudence in Georgia. Have you seen any data or specific information, an analysis of how our court system is actually operating that would, in your mind, point to the collateral source doctrine as it exists as problematic?
I hope I'm answering your question.
Was that a bad question? Let me fix
Well,
it.
I'm gonna
Let
try
me
to
fix
answer
it. Let me
try
fix
to
it.
answer it this way.
My question is, why all of a sudden in 2025 is the collateral source doctrine so much of a problem in the way that we handle our jurisprudence in this state?
I don't know of a specific problem that this is meant to address. I think within the concepts of, I think the governor is trying to address the problems that everyday Georgians see with increasing insurance premiums. That's what they're trying to address. My concern is that this provision does not do anything to help average Georgians.
Representative Evans.
Thank you, Mr. Chairman. Thank you, Mr. Snipes. I've been thinking a lot about this premium cost since the other witness and then Chairman Dr. Newton got up here. or was asking you your question about, well, what keeps you from asking the jury about the premiums, or asking them for the premiums. And I think there's probably some issues with some of the other sections of the bill that might prevent that. But one thing that I think is a reason it would be hard for a lawyer to make that argument, I want to see if you agree with me, is that when could the plaintiff ever prove that the insurance premiums were a result of the injury, which is what the case is limited to? They would have bought the insurance anyway, right? So I think that's a problem in recovery, and I was wondering if you would agree with me in answer to Chairman Newton's question.
Yeah, I'll first go back to what Mr. Carroll said. I'm not good at math, so I wouldn't have been able to handle the numbers part of this. But beyond that, I don't know that the jury would ever, I don't believe, would know what someone spent. I think what we're looking for is, though, there is a benefit that someone who has health insurance pays for, and that's a contractual adjustment. And what generally this would do is allow a jury to give the benefit of that contractual adjustment to the party that caused the harm. And that's the concern I have.
And just on what's good for the goose is good for the gander kind of theory, nothing in this bill, I think we've established nothing in this bill, excuse me, is going to let the jury know that the defendant doctor, that the defendant driver is not coming out of pocket. They've got insurance. Do you think that we have that in our law because we're worried that the jury would say, oh, well, this guy's not going to lose any money, so let's give him more? And why does that not go both ways, I guess is my question.
The collateral source rule, in my opinion, is sound public policy. Jurors don't need to know the amount of liability insurance that's available because it suggests something, just as they don't need to know what health insurance paid. And generally, the relative wealth of the parties or lack of wealth of the parties is not something that jurors need to know. They need to decide cases based on the evidence of liability and the amount of damage, and that's what they need to decide.
Thank you.
Do you have a question?
Yes, sir. Thank you, Mr. Chairman. Mr. Snipes, thank you for your testimony. I would agree with you, and I hope that there is an opportunity to find common ground on both sides of this issue. Going back to Chairman Newton's question, on lines 348 and on lines 355, it notes that damages would be limited to reasonable value. Specifically, I'm sorry, that's lines 350 to 351, and then again on lines 355. My understanding is that essentially if we're talking actual hospital, this would essentially allow insurance companies to pay out less than what actual hospital expenses would be. At least that's what this would permit. Is that not true?
Well, I mean, even now, though, if a plaintiff introduces a bill, a defendant can challenge the reasonableness of the bill as not being, either the incurring the expense not being reasonably necessary, or the fact that the bill is not similar to a bill for the same type of services in the same community. So there's already an ability to challenge that. I don't think that changes. It may codify it in a different way, but I don't think that substantially changes what the law is now.
Thank you.
Thank you. I don't believe you have any further questions.
Thank you, Mr. Chairman.
Thank you for establishing that you and I share in common the trait that, unlike Jethro Bodine, we're not real good at ciphering. All right, Ms. Hoying, Melanie Manis is up on deck next. Ms. Manis. Ms. Hoying, please, when you're ready.
All right. Thank you, Mr. Chairman and committee members, for having me today. My name is Denise Hoying. I'm an attorney in the state of Georgia. I've had a little bit of a different background than most of everybody else that's been up here. I am a Vanderbilt educated chemical engineer. I worked in industry for a number of years. I then became a stay-at-home mom for a number of years, and then I went to law school at Georgia State at the night program so I could be home with my children during the day. Excuse me. And I've been a practicing attorney for the last 15 years, first on the defense side, now on the plaintiff's side. I work with Pete Law and Mike Moran. You heard from Mike yesterday. I have two daughters. They are 22 and 23. They are, one of them, a 2L at University of Georgia. So we've lived here for a very long time. We're ingrained in this community. And I watched the testimony yesterday all the way. Y'all had to be here. I watched it because that's just who I am. And I'm here today to take you back, throw back to Mr. Masterson, who testified. He was your last witness last night. I know Mr. Masterson. He is a very skilled, very smart, experienced trial lawyer. He is probably the best negligent security trial lawyer, defense lawyer in this state. He came down here to give you an example of a negligent security case that survives this bill. That was his task. He had all the time in the world to come up with whatever example he wanted. He has defended hundreds of these. And the example Mr. Masterson gave you was, and I went back and I watched it again this morning to make sure I got it right. If somebody at Waffle House goes into the stall and is sitting in there every day and repeating that conduct every day, and Waffle House knows about it and doesn't do anything, they can recover under this statute. First of all, that's not a real fact pattern, okay? If it would never happen. The facts are, and the folks, the plaintiff's attorneys who have spoken have said, give us a real world example. No real world example survives this. That's not a real world example. Nobody, Waffle Houses are small. Nobody goes in the bathroom every day and shoots or sexually assaults somebody repeatedly day after day after day, and nobody does anything. That doesn't happen. But even if it did happen, that fact pattern 100% does not work under this statute. And engineer, I want to go through the words on the page to describe for you how that is. You got to start on line 203. An owner or occupier, here Waffle House, shall be liable, and then it goes on for negligent security, if the plaintiff proves on line 207 the wrongful conduct by the third person that caused the injury sustained by the invitee was reasonably foreseeable because the owner or occupier, here Waffle House, and it gives a couple of different ways, and in Mr. Masterson's circumstance, you got to go to line 218. Prior occurrences of substantially similar wrongful conduct by the third person whose conduct caused this injury, if the owner or occupier knew the third person was or would be on the premises and knew of such prior occurrences of substantially similar wrongful conduct. Okay, well, what does prior occurrences of substantially similar wrongful conduct mean? Now you got to go to line 183 to figure out what that means. And when you go to line 183, it tells you that that means prior occurrences of wrongful conduct, and they give you some descriptions of that wrongful conduct. And then there's some conditions. And I want to focus on the third condition. They are and conditions. It means you have to meet them all, but in the interest of time, we're going to focus on the third condition, lines 189 to 192. The reasonable person in the position of the owner or occupier must understand that a specific and known physical condition of the premises has created a risk of such wrongful conduct on the premises that's substantially greater than the general risk of wrongful conduct in the vicinity. That means the bathrooms at Waffle House, standing alone, must create a risk of wrongful conduct. The bathrooms just are not a physical condition that creates a risk of wrongful conduct, and certainly not a greater risk than the other bathrooms in the vicinity of the premises. That example just doesn't work. There are, as you go further through the bill, 2 other conditions you must meet. They're all and conditions, 2 or 3 others. It doesn't make it under those either. There's more physical condition things in the rest of the conditions. You just don't get there. So even after spending a lot of time and careful thought, this defense attorney who's done hundreds of these cases could not come up with one single case to present to you that survives this bill. And as the other plaintiffs' lawyers have said, that's because no negligent security case survives this bill. This bill needs amendments so that businesses who do not take reasonable precautions are held accountable to protect Georgia's citizens. Thank you.
Thank you for your testimony. I don't see any questions. All right, let's see. We had Melanie Manis. And John, tell me how I pronounce your last name again? Tanj. All right, hopefully I can remember in 10 minutes or 8 minutes to get it right. All right, Ms. McManus, go ahead.
Good
And I'm not
afternoon.
giving you 10 minutes. I want you.
I don't need 10 minutes. I'd probably be before the buzzer. My name is Melanie Manis. I am 40 years old, and I am a survivor of human trafficking. Last summer, I was in the Red Roof trial case. You guys have done a lot the past few years to try and help women such as myself and women who are still out there with no voice. In 2020, you guys passed the Debbie Vance Act, which I was the first survivor in Metro Atlanta area to have my record vacated, restricted, and sealed. And I never got to actually thank you, gentlemen, but thank you. Since then, it has completely changed my life. I've become a business owner, a homeowner, and to the best of my ability, a upstanding citizen. When I was in this Red Roof trial, it was so hard to testify, every single bit of it, from beginning to end, because I didn't go searching for this. It was just kind of like it was Judgment Day, and it was time for me to be given back what had been stolen from me, and most of that was a voice. The little bit of time that I had to get up on the stand and testify was really hard. I don't know if I would have been able to do it 1, 2, 3 more times. I think it's very, very hard because women in the sex industry don't have a voice as it is. They're told what to do, when to do, how to do it, and if you do it any other way, there are severe consequences. And to have to repeat that 1, 2, 3 times. I was in a case with 10 or 11 other girls. Some of our girls couldn't even hold it together on the stand. Right is right and wrong is wrong, but for people who, again, don't have a voice, it takes every bit of courage inside of us to come up just one time and say, this is what happened to me. So how do you guys expect us to be able to do it 2, 3 times and to find anybody to be able to help anyone? It doesn't help anybody at all. But things you guys have done, like the Debbie Vance Act, have helped a whole lot. I really pray that you guys don't pass this because girls need a chance to be able to get it out once. Give them one chance to get it out. 2, 3 times, that's what I go to therapy for. That's what I use the blessing of my settlement for. I go to therapy. I go and seek out people who are able to help me to heal through the rest of this process. Thank you for letting me share.
Thank you. You don't have any questions. Thank you for your testimony. Mr. Tanj. Did I get it right? And is it Joanne Dorshaw? Did I get the name right? Yep, you're on deck, ma'am. Thank you. Please proceed.
Thank you. I'm going to apologize in advance. This is difficult, but these are some questions that my clients have been asked to testify about, and all my clients are survivors of sex trafficking. Have you ever been defecated on? Have you ever defecated on someone else? Have you had anal sex? Have you had group sex with multiple men? If so, how many? Have you ever stomped on a man's genitals? What is the grossest sex act that you have ever committed? So how did that feel? Doesn't feel good, does it? And what if you had to answer yes to any of those questions? And what if the next question was, well, tell me about that? Because that's what my clients have to do. And a lot of people have talked about it's hard to testify twice. What about sexual abuse survivors? That's what we're talking about. And what if you had to do that 2, 3, 4 times with the deposition, 3 phases of trial, I did the Red Roof trial. I examined Melanie. I examined other witnesses in that trial, four of my clients. You have no idea the amount of preparation that takes. And it's not fact preparation. It's emotional support, building people up to believe they can do it, providing them the tools. It's having a support system when they get off the stand. I've seen my clients testify in that trial last July. There's only 10 women that have ever testified in Georgia in a civil case about sex trafficking, and it was in that trial. And I've seen them walk out of the courtroom like this room, take a left down the hallway, turn the corner to where nobody could see them, and fall on the floor. And every single one of them is extremely proud of what they did, and they feel a great sense of relief. But the last thing you want to see when you've climbed the mountain is to look up and see there's another mountain right behind it, and another one right behind that. And so and another important point is we talked yesterday about this exception that is already in there. That applies to a different article. So it does not apply to this bifurcation thing at all. And so, you know, there is no exception for this for any kind of sexual abuse or sex trafficking victim, but there should be. And I came back today because there's so much in this bill that interacts in different ways with my clients and my clients' claims. And this one would be particularly damaging to any sex trafficking survivor in the state of Georgia. And finally, I know we have short time. I watched yesterday also, I watched some on video. The businesses that support this bill yesterday said that they don't want to protect bad businesses like hotels that allow sex trafficking. Everybody seems to agree on that. But that's what this bill does. And if the bill's not amended, it protects hotels that allow children to be sold for sex. And so if you're against that, then you need to amend this bill. Thank you.
Thank you. You have one question, Representative Evans.
Thank you, Mr. Chairman. Thank you for being here again. We talked to Mr. Masterson and some others yesterday about, you know, tell me a claim that survives. And we had plenty of plaintiffs' lawyers telling us that no claims survive. The flip side we haven't talked about as much. Could you provide any insight on how all these conditions that now would the plaintiff would have to meet all these conditions? The defendant knew this, the defendant had to do that, there had to be all these conditions. I think there's over 10 of them. Can you explain in a real world how having to have all those conditions benefit these motels that are allowing this sex trafficking to go on in our state?
Sure. And I may have done a poor job yesterday, but when I say, you know, in this one section of the definition of particularized warning, there's 10 types of knowledge you have to have. For people who aren't lawyers, I mean, that means you have to have evidence that meets every single one of those. And so if you have evidence of 9 of those things and you don't have evidence of the 10th thing, you lose your case and you're gone, right? And so one of those is, you know, you have to know the identity, the location, and the time of what's going to happen, right? So you have to know, a hotel would have to know the identity of the trafficker, the location of the trafficking, and the time of the trafficking. And I'll just tell you, like I said yesterday, a lot of these hotels know a lot, and they are criminally involved with the traffickers. But, I mean, that means that if a trafficker came into the front office with a 12-year-old and he said, I'm going to traffic this 12-year-old on Monday out of room 210. Well, if he decides, you know what, let's work the weekend, I'm going to do it on Saturday instead, that hotel doesn't have any liability because they didn't know he was going to do it on Saturday. They thought he was going to do it on Monday, and so they don't know the specific time. What if he sees a buddy down the way? Because a lot of times, they're not usually the only trafficker in these kind of hotels. What if he takes him to room 310? The hotel's probably off the hook because that's not the same specific location that they knew about. I mean, these are ridiculous outcomes that could come from this bill. And a hotel could have all the knowledge in the world, and if the date changes, if the location changes in the hotel, there's no liability for these businesses that it seems like everyone agrees we want to get rid of and wants to allow people to sue for that. But nobody's going to be able to do that if the bill passes as is.
Representative Miller, or Chair Lehman.
Thank you, Mr. Chairman. This has been bothering me actually a lot because I also prosecuted crimes against women and children, sex crimes, and I know exactly what you're talking about. And how hard it is emotionally, even on the lawyers who do these cases. So first, I want to thank you for this work. The second thing I want to sort of talk about a little bit, because I want your perspective on it, and I'm going to go a little bit to sort of the arguments that you all are able to make about damages and what you can say and what you can't say. For a crime like a sexual assault or sexual abuse, many people have a challenge really understanding all of the dynamics of the injury to the victim, what it does to them. We talked about it in the DA's office as holes in the soul. That's what we would say.
Right.
What impact do you think it has on restricting an attorney from arguing within the facts and the evidence, which the judge is going to require you to do anyway, but making that presentation to a jury about what kind of justice or what justice should look like for a person who has been silenced with no voice? How important is it for an attorney to be able to do that?
I mean, it's hugely important because, here we're talking about something intangible. You know, like I had a client who testified in a criminal case actually, and she testified very eloquent that what happened to her was the loss of her childhood, right? And a 14-year-old's going to have a very hard time explaining an economic number that her childhood was worth, you know? And that's what happened to her. And that's what your lawyer is for. She's not supposed to sit down and do some math and come up with a number and be able to testify like, I actually think it was, 1.25 million would be right, That's what your advocate is for. That's what I'm here for. When she gets asked those questions, she doesn't have to object. I object. I'm the one that needs to defend her and say that, These are children that never got to grow up, and they need their advocates to be able to explain the process to the jury and to guide them through this, and sex trafficking survivors need all the tools they can get. They don't need to be hindered or hampered at all, and that's what we're doing. I mean, that's it. Everything that limits the ability of their advocate to speak for them is a harm to them, and it's only going to make it more difficult. And I mean, the point of those questions and some of this stuff is, the point is to chill lawsuits. The point, so somebody hears about that and they say, boy, I don't want to do that. There's no way. I'm not going to do that. And the point of some of those questions was in hopes that our clients would just drop their lawsuit because they don't want to go testify. That was bad. The deposition was so bad, so painful, 7 hours. And they all go 7 hours. They take every minute they can take to abuse my clients in a deposition. And they just hope that they'll stop because it's too hard. And we shouldn't make it hard. We shouldn't make it any harder than it obviously already is.
Thank you. I don't believe you have any further questions. Thank you for coming back and testifying today. All right, ma'am, and I'm sorry, is it Dora Show? All right, come on forward. And Alex Weatherby, you're on deck. When you're ready, ma'am.
All right. Thank you. Thank you so much for giving me the opportunity to speak. It's really an honor to be here in Georgia. I'm from New York. And just a word about me. I am the executive director of the Center for Justice and Democracy at New York Law School. I am also the co-founder of a consumer coalition called Americans for Insurance Reform, which I founded along with Bob Hunter, who was an actuary and actually the federal insurance administrator under Presidents Carter and Ford. We've done a lot of reports about the insurance industry and its relationship to tort reform, beginning in the late 1990s. And what we have found in our work for over 2 decades on this is that when it comes to reducing insurance rates, tort reform has been a colossal failure. These studies, which are based on ISO data, which was insurance data that was mentioned in the hearing yesterday, shows that there is no correlation, between enactment of tort reform and insurance rates. States with few or no tort restrictions have experienced approximately the same type of rate changes as states that enacted severe restrictions on victims' rights. And what has the insurance industry's response been to our reports when we started to do it? Well, the American Insurance Association put out a press release saying, we never said tort reform was going to reduce insurance rates. And they are not the only entity in the insurance industry that has said this. Now, I know I have very limited time to explain why that's true. I'm happy to answer questions about it. But I also do want to talk about the jury system as well, because several of the provisions of SB 68 are direct attacks on the power and the authority of juries, sections dealing with bifurcation and so-called anchoring, the premise of which is that Georgia citizens who sit on juries can't be trusted with information to assess damages by listening to both sides of a case. And then there's the repeal of the collateral source rule, which many have talked about already, which really completely undermines what the jury decides a wrongdoer's liability should be. And by the way, in 2003, Texas repealed their collateral source rule. Well, rates have been going up to this day. But one of the things that I always find kind of upsetting about discussions like this, and what I think gets lost, is that the civil jury system, which is to be let alone without interference from anybody from the outside, it's one of the great achievements of American democracy. We fought the Revolutionary War in part over protecting the right to jury trial. Whether you're, right, left, blue, red, it is one of the most popular institutions in the country. Decades of objective studies by researchers show them to be capable, effective, and fair decision makers who weigh evidence fairly, both sides, and reach decisions similar to how judges or juries would rule. So I know I need to wrap up. I will just say that you cannot solve insurance problems on the backs of sick and injured children by stripping away their rights. It's not only cruel, it doesn't work. And I'm happy to answer any questions.
Thank you. You have a question from Cheerleader Miller.
Thank you, Mr. Chairman. There is one thing, and I've read several of the reports that you guys have issued over decades, and it really does seem to be deja vu all over again in every place where these campaigns are run, and a crisis comes to be with lawsuits, and then we have to enact tort reform. One of the things that has been said by many people in this conversation is that Georgia is a judicial hellhole. I personally, as a lawyer who has practiced in this system and who has appeared in front of many judges and tried cases in front of many juries and seen justice served in many cases, most of them I agree with, even the ones I lost. Can you tell us a little bit about where this moniker, judicial hellhole, comes from? Who has insulted this state by giving us that name? Can you describe that organization? Have you studied it?
The term, it's a PR term that was developed by a Washington, D.C. based lobby group called Americans for Tort Reform, which was formed in 1986 to represent the interests of large corporations who have a financial stake in restricting lawsuits. So they have put these out. There is no empirical basis whatsoever to this report. It has been debunked and criticized endlessly by academics, by experts, by journalists, they continue, like the U.S. Chamber of Commerce, put out bogus reports like this in order to pit states against one another, to attack the independence of judiciaries, and to attack juries.
Thank you, Mr. Chairman. Thank you so much for being here. I think you mentioned during your remarks that you've studied this a lot and you've seen states enact tort reform and premiums don't go down. Why is there not a correlation to that, if you know? And then more importantly, because I don't want our companies to have these skyrocketing insurance costs, and so I am interested in ways that would actually bring them down. So could you speak to why bills like Senate Bill 68 don't work, if you know, and then what should we be doing if that's actually our goal?
Well, one thing I want to point out is that insurers as has been discussed here, they mostly make their money by investing the premiums that they get. This is particularly true in the commercial lines, where they can hang on to money for 5 to 10 years. And as a result of the way they make money, the profit cycle is cyclical. Rates will go up, they'll stabilize for 10, 12 years, then they'll go up again. It has a lot to do with the kind of the Byzantine way the accounting works with the insurance industry, which gets a little complicated, but in any event, it is not driven by lawsuits and claims. And what we always find is that the claims have never spiked, particularly, when you have to consider inflation and those sorts of things, but claims themselves are never spiking. So what's causing it is this profit cycle. This is something, it's a type of market that the entire nation experiences, not just the state of Georgia. We are in what's called a hard market right now, which is characterized by high rates. Every state is experiencing this. It's got nothing to do with a state's legal system. The states that have been, a few states have tried to get control over this. I recall back in 2005, Illinois passed a very strong law, which was based on transparency, opening books, forcing the companies to report more information, and getting some kind of better control over rates. And during the years that law was in place, and eventually it was voided out because of another law it was connected to that got severed. Anyway, it's complicated, but in any way, there were a number of years when this law was in place. What the insurance department found is that rates went down. Companies came into the state, competition was increased. So all these great things happened just because the industry was forced to be more transparent and was forced to be more accountable. And that's, I think, the way to do it.
That was because the legislature or the governor, someone had said, or the insurance commissioner perhaps had said, we want insurance to be transparent, not because of tort reform, that the rates went down.
Exactly. They said it was not because of tort reform, it was because of this insurance regulatory law.
And one more question. We've heard in this committee, I think it was last week, or a couple witnesses have talked about this U.S. Chamber report about the tort costs in Georgia are just so much higher than everybody else. And could you shed some light on that? What's actually included in tort costs, and is Georgia actually really out of whack with any other state? If you could tell us about that.
Here's another example of completely fabricated data. They use inflammatory words like tort cost or tort tax to get people upset. If you read that report, what you find is that all they are looking at is insurance costs. So they are including in this all the multi-million-dollar salaries of insurance executives, all their bonuses, all their jet planes, all the advertising that you see. They are trying to convince people that that's a tort cost. In addition, they're including things like repairing scratched up cars that these claims don't come anywhere near a court. So it's a complete fabrication, and again, just like with the Hellholes report, this report has been widely debunked, and unfortunately, they have a lot of money, so they keep doing it. So, and hopefully people don't pay attention to it.
Representative Miller.
Thank you. This is helpful, and this sparked a question for me. So we hear about, we have been hearing about malpractice claims and malpractice insurance going up and all of these things. And we know that in Texas, at least my understanding is, and you can tell me if I'm incorrect, and if you know, that sweeping sort of tort reform that was supposed to deal with all of the issues that a lot of the hospitals and doctors and folks are saying now, and the tort reformers are saying now. What happened in Texas as it relates to claims or premiums in medical malpractice after the sweeping legislation was passed there?
Right. So in Texas, the tort reform groups and the insurance industry got voters to vote to strip their own rights away in their constitution, because this was not even allowed to be passed prior to 2003. They convinced their voters that if they passed tort reform there, that doctors would come back to Texas. They were fleeing Texas, and insurance rates would start coming down, et cetera. I mean, it was completely made up and fabricated public relations that was done. And they gave up their constitutional rights. The legislatures passed a whole bunch of tort reforms, including repealing the collateral source rule, but others as well, in order to bring down insurance rates for doctors and bring them back. And what the studies, and there has been a lot of academic work done to look at what happened in Texas, and what they found is the rates continued to go up. It had no effect really on rates. It had no effect on doctors. Actually, doctors were never leaving to begin with. It was fabricated. And, you know, to the extent that, you know, there's been any impact on physician shortages, that law had no effect on it at all. I mean, there are a lot of reasons why we have physician shortages in this country, and I'm assuming the same in Georgia. It's got nothing to do with malpractice. It has to do with the burdens, the burnout, the difficulties of dealing with the healthcare system. There's countless articles that you see about doctors writing, I can't take it anymore, I'm leaving the profession. They're leaving younger than they used to, or also there's a lot of retirement and not being replaced. There's so many reasons. And if you look at the surveys of doctors that are done, they actually list malpractice at the very bottom of the list, if it's even on the list. It is not, you know, we have plenty of studies and surveys about this, which I'm happy to supply. But basically, with regard to Texas, people lost their rights. They were completely taken away from them, and it had no effect whatsoever on the medical malpractice market.
Whip Park.
Thank you, Mr. Chairman. What's happening in Florida? I know there was prior testimony given that after tort reform passed 2 years ago or so, that truck insurance rates went down. And then now, of course, there's a current investigation by the Republican speaker. But could you enlighten us a little bit more there?
Yeah, I mean, you know, we all know about the scandal in Florida. We've heard about this, how, you know, the industry hid data. They hide data in all kinds of ways, which is another, an additional conversation. I think what's happening, that the state is under enormous political pressure right now. The insurance industry is, there's a microscope on them, and they're going to slightly reduce rates perhaps. But what we know will happen is, as soon as nobody's looking, those rates are going to go way back up again. And we're already hearing insurers, auto insurers, talking about how the tariffs are already causing them to raise rates. There are a lot of other factors happening. It's not, there's no connection to the tort reform law. And I think you have to sort of step back and look at what has actually happened around the country to every state that is, and I will say one more thing about Florida. You know, we have a very kind of short memory in this country. Back in the early 2000s, Florida passed a bunch of tort reforms that were later found unconstitutional by the Supreme Court. And if you read that decision, the Supreme Court went after the insurance industry for misleading, basically, the lawmakers as to what would happen if these laws were passed. And in fact, at one point, I know that the representatives, a lot of representatives in Florida were put under oath at the time. And if I could just quote from one of the excerpts from the Supreme Court decision.
Quickly for me, ma'am.
Quoting Robert White, the president of First Professionals Insurance Company, testified during Senate Judiciary Committee meeting that tort reform would achieve virtually nothing with regard to stabilizing medical malpractice insurance rates. And the entire Supreme Court decision was quoting people like this. And as a result, they struck it down. They struck the tort reform down as having no rational relationship to the arguments that were being made in favor of it.
Thank you, ma'am. You don't have any further questions. Mr. Weatherby and David Stiegel is on deck.
All right, my name is Alex Weatherby. I'm an attorney in Atlanta. For 14 years, I was an insurance defense lawyer until last year. So now that I've come to the dark side, I can actually tell you a little bit about what the defense side was. So for 14 years, we defended the largest companies in the world, and what we called nuclear verdicts were actually called outlier verdicts. That's how we would talk about them, because when you graphed them out, they were an outlier. The reason why they were an outlier is because they were uncommon. They didn't happen very often. At my law firm, we defended 7,000 of these cases. I know because we started at file number 1 and kept going. Out of those 7,000 cases, we had 0 outlier verdicts. We had 2 settlements over $1 million. One was to a man who was on the way to his child's baby shower with a present next to him. We pulled out in front of him and killed him. The second was a person who we pulled out in front of again and was paralyzed completely on the right side of his body. No way would anybody in this room exchange the amount of money for what these folks went through. The outlier verdicts are uncommon. They're also often uncollectible. The vast majority of what you see out there posted on attorneys' websites are uncollectible. I know because I have one on my own site. Okay. It's a $27 million verdict I got at the Fulton County Courthouse. And what happened in that case is Tom's wife, Pam, was picking up their son, Christian, from a soccer field about half a mile away. And a drunk driver who was underage had been getting drunk at a bar we later found out made their money on serving underage people and not IDing them at the door. T-boned the car. Pam dies instantly. Christian crawls over his mom, kicks out the door, and survives. So they awarded us $27 million. Now, even though it was uncollectible, that doesn't mean it didn't matter. That bar is no longer in existence, and everybody here is better off. Many of the folks in this room will actually drive right by where the accident happened. I mean, it was literally half a mile down the road, and they were continually putting drunk drivers. So MAD, Mothers Against Drunk Drivers, is right. If we had this law, that judgment would not have happened. And why? Well, one of the main reasons is that you can't argue pain and suffering until the end. Well, in Pam's case, she died on the scene. I mean, I think the medical bill was about $1,500 to take her to the coroner. So there was no real special damage. It was all about what's Tom's life worth, the fact that he's still not married 10 years later. What's that worth? My final thing here is that it's explainable. When you look under the results of any of these outlier verdicts, and we've heard a lot about them today and yesterday, these are not my dad's plumbing company, okay? They're not employing 10 good old guys who are going out and doing good work. There are people who are doing shady things, and they do it in the courtroom and out. And that's why, and I understand you have a former judge up here. That's one reason I wanted to bring up, which hasn't been mentioned today, the motion to dismiss component. The folks that are most likely to take advantage of the fact that our state courts are overworked are these bad acting defendants like that bar that killed Tom's wife. They'll file a motion to dismiss. It will be pending for years. We already have a requirement that all motions be ruled on within 90 days. It's OCGA 15621. It doesn't happen, as the judge will tell you guys. It doesn't, not because they're not good judges, but because they aren't able to get to it. They just have way too much to do. You'll have cases pending, families that are trying to get over a loss for a year.
Thank you. I don't see any questions. Thank you for your testimony. David Stiegel. And then next up is Jen Jordan.
Mr. Chairman, members of the committee, I'm David Stiegel. I'm Principal Consultant of Risk Management in RCES, Risk Consulting and Risk Management. We're an insurance consulting firm. I started this firm in 2007 after 30 years I was originally trained as an Aetna casualty and surety underwriter, went on to be an agent and an agency owner and a reinsurer and an insurance company executive. And after all these jobs, although not a very good resume to get hired again, it was an excellent resume to become an expert, an insurance expert. I was called by the Georgia Trial Lawyers Association several months ago to do a report to study the Georgia insurance market and come to findings based on a lot of empirical data that we gathered through the National Association of Insurance Commissioners, which is the body by which the insurance commissioners' offices of all of the states send to this organization to do analytical studies. Georgia's commissioner office sends this information along with all the others. So there's no question of what facts I'm using. We're all should be using the same facts, and that's what we're coming from. The highlights of my findings were that the Georgia insurance market is stable, competitive, and profitable to the insurance industry. Attorney involvement is not the cause of high premiums. The number one cause of high premiums is that Georgia has almost 2 times as many accidents as the average of the United States, actually 190% to be exact. Inflation and the increased auto part prices are the other contributing factors. Carriers are not fleeing the Georgia insurance market as some have said. In the report from 2017 to 2023, 23 markets did leave, and 21 carriers did leave the market, but 21 carriers came into the market too. So I wouldn't call that a mass fleeing of the market. Georgia also has a profitable insurance market, believe it or not. All the insurance industry sources simply give you underwriting information called loss ratios, which is basically losses divided by premiums. And only 4 years out of the last 40 have they had a profitable underwriting period. So that is obviously not where the insurance companies make their money. It's from investment income. For instance, in 2023, the total insurance industry in the U.S. had a 102% loss ratio, so they spent $2 more out of every 100. If they collected 100 in premium, they spent 102 in losses, which doesn't sound good, but they made $90 billion in investment income. So that has to be taken into consideration, and it is by insurance company executives when they're determining rates and market share and other things that they determine about how they're going to operate in a particular market. I think my time is up.
Your time is up, but if you'll just close for me.
Pardon me? Oh, okay.
If you wish to close,
Commissioner King issued a report that I was asked to rebut on. He used a lot of information that he said was proprietary and didn't say exactly where it came from. Didn't know that insurance company data was proprietary, but what it apparently said was policyholders seldom recover full indemnity on physical damage claims without an attorney involvement. Also, there was people were saying that attorney advertising increased premiums. Well, when asked in a survey, only 13% of the survey people said that was why they called an attorney. 87% had several, 8, 9 different reasons why they did. The other thing is that the King report also mentioned numerous times nuclear verdicts. I didn't find one from 2014 to 2023.
Thank you very much. I don't see that you have any questions. We appreciate your testimony. All right, Senator Jordan, and Leighton Moore is next.
Good afternoon. I'm going to be quick, gentlemen. All
Thank
right.
you.
My name is Jen Jordan. I'm a former state senator. I've served with some of y'all, but more significantly, I'm a lawyer. I have practiced for, unfortunately, about 25 years. I've represented both defendants and plaintiffs, and I still do. And let me tell you something, with respect to this bill, the only people who benefit are insurance companies and insurance defense lawyers. And let me tell you why. Specifically, when you are a business or if you are a defendant in a case, let's take a medical malpractice case. You're a doctor, you've been sued. It is stressful, right? It is incredibly stressful. You want to get it done. All this does is it delays the process by years, okay? So I come in here, I'm looking at this, I'm like, well, this isn't just like a pro-defendant bill, right, or a pro-plaintiff bill, because it hurts both. Who the heck is benefiting here in terms of the delay that this puts into the process, right? It's the insurance companies. And specifically when we look at, with respect to the evidence and the testimony that's been given, that what about this whole profit cycle that they're in? Look, insurance companies want to hold on to their money as long as possible, right? They put it into the markets. It's a 5-year, 10-year kind of horizon. They don't care if the defendant doctor is sitting there and wants to settle, right? The process is completely shut down, completely delayed, and at the end of the day, the only people that get hurt are actually the parties, the judge, who y'all are taking away a lot of power from, right, and the juries in this state. And let's be clear, the jury system is so incredibly important. It is a conservative concept in that we don't want the government coming in and telling us what to do. We don't want regulation. What we do want is we want the people in our communities to be able to say this is right or this is wrong. And as between the innocent person who's been injured and the wrongdoer, who should have to pay for that? It absolutely should be the wrongdoer. This is a travesty, and this is being pushed by an industry that sees record profits, and the only people, again, that are going to be hurt are the people that elected you to be here. Thank you very much.
Thank you. Let's see, who is next? Leighton Moore, and then Morgan Knowles is next.
Thank you, Mr. Chairman, honorable members. I'm going to speak to Section 7 and specifically to the application of that section to future damages. Current law permits a plaintiff to prove and recover the face amount of a medical bill. Evidence of whether they have health insurance or what amount that insurance will pay is excluded, just like the evidence of a defendant's liability insurance is excluded. And there are good reasons for that. On the defense side, the worry is the jury will award more if they think the insurance company is going to pay it. On the plaintiff's side, one concern is the jury's going to award less if it believes the plaintiff's insurance company will pay for future care. This bill changes that in a way that only benefits tortfeasors and their insurance companies. The supporters of the bill refer to the difference between the face amount and the discounted portion as phantom damages, but it's not. When the plaintiff has to go collect those damages in a lawsuit, they have to hire a lawyer to do that. And most people can't pay a lawyer by the hour the way an insurance company can. They have to pay a contingent fee. So that comes out of the amount that's awarded. If the amount that's awarded is only the cost of care minus what it's being referred to as phantom damages, then the attorney's fees come out of that cost of care and the money's not enough. But without the attorney, the money would never have been awarded in the first place. And then many plaintiffs have to pay their insurance companies back. And as Mr. Carroll pointed to this, especially if they are insured by Medicaid, if they're a service member insured by TRICARE, if there's a self-funded ERISA plan like Mr. Carroll's plan, and for future care, there can be Medicare set-asides and Medicaid set-asides that are mandated by federal law. Some insurers don't have the right to get paid back. They're subject to what Georgia law calls the made whole rule. The rules that govern this repayment are very complex, and many lawyers don't understand them. Rules like subrogation or the enforceability of hospital liens, ERISA, probably the most complex federal statute there is. The secondary payer acts for Medicaid, TRICARE, Medicare. Lawyers like myself hire specialized attorneys to address these issues because we frankly don't understand all the ins and outs. And for future medical care, we hire specialized lawyers to set up special needs trusts for permanently injured plaintiffs who are going to need medical care for the rest of their lives. The facts that are necessary to determine whether the insurance company will need to get paid back aren't always known at the time of trial. Often there are separate declaratory judgment actions, or because the care hasn't been provided yet, the facts aren't fully developed. If the award's too low, the plaintiff can't come back to the jury a second time. The plaintiff can't come back, so the money runs out, and what happens then? When a plaintiff is permanently injured, can no longer work, and still needs medical care, taxpayers take that money over. Taxpayers start paying for it through Medicare and Medicaid. The fix, the only practicable thing to do, I'm cutting to the chase, is to let the jury determine how much the needed medical care costs and not try to speculate on how it will get paid for. That's current law, and that's the right fix, especially as to future medical care. We can't predict if a plaintiff is even going to have health insurance in the future, whether Obamacare will get repealed, whether Medicaid will get cut, what the reimbursement rates will be. There's no way to predict that from the standpoint of 12 people in a jury box. So Section 7 is not good for any case, but if anything like it is going to pass, it should be amended and restricted to past medical costs and not future.
Thank you. I have a question from Representative Miller.
Okay, thank you, Mr. Chairman. Thank you for that. That's a good point, and I just want to make sure I understand what you're saying. Is the fear that if a jury hears about health insurance that an injured person may have, that they will diminish the value of future care because they will be led to believe that insurance will cover it? Is that what you're saying?
So my understanding of the way Section 7 works is that if the plaintiff has health insurance, the charges for medically necessary care, treatment, or services shall be the amount the insurance company pays. And you don't know what that's going to be in the future. There's absolutely no way to predict that. If the plaintiff has Medicaid, you don't know what Medicaid reimbursement rates are going to be. If the plaintiff has private insurance, you don't know if they're still going to have it. You don't know if the pre-existing condition exclusion from Obamacare is going to get changed. And so what are we supposed to do as trial lawyers? Are we supposed to hire political scientists and historians to come in there and predict the future course of the law? Or health policy experts to say what insurance rates are going to be 50 years from now when a baby's got a brain injury and you're trying to provide for them for the rest of their life? And on the day when that money runs out for that baby, that's when taxpayers start taking over and the tortfeasor stops paying. And so that's what we're trying to prevent.
Thank you. You have no further questions.
Thank you.
All right, Morgan Knowles. Ms. Knowles, you're the last opposed witness, and after you, we'll take a quick break for about 5 minutes and come back in and take up those in support. But please go right ahead.
Awesome. Thank you for taking the time to hear me out. My name is Morgan Knowles. In 2018, I was seriously injured in a really bad car wreck on 285 after I was rear-ended by two different individuals. This happened just 4 months after I lost my fiance to suicide. I was a newly single parent trying to navigate a world that I struggled to navigate. And then I was thrown into the world of lawsuits and tort. It was an incredibly difficult journey. I learned very quickly that I was not allowed to even talk about my insurance company when it came to being at trial. So both of the two individuals who had hit me, their insurance carriers had actually paid out their limits. So it was up to my insurance company to cover the cost for the remaining medical bills that I had, which was in excess of $35,000, $40,000. My insurance company told me no, that they would offer me $0. So I had to file suit. I could not name my insurance company in that suit. They basically got to hide behind a veil. But in fairness, my own health insurance wasn't to be disclosed there, but Senate Bill 68 takes that away even. So the scales were already tipped in favor of tortfeasors. And what Senate Bill 68 does is allows these tortfeasors and their insurance companies to now introduce other insurance information while still hiding behind that same veil that they hid behind with me. And that just doesn't sit right with me. I was a Georgian just going to work. I'm just like all of you. There's nothing special there. But it was hard enough for me then. I cannot even imagine trying to navigate it after Senate Bill 68. So I kindly ask you to please look at the bill. Please look at the implications for the regular, just normal Georgians like I am. Thank you.
Thank you. I don't see that you have any questions. Thank you for your testimony. All right, ladies and gentlemen, we'll take a 5-minute break and then get back here and try to get wrapped up. is Brett Johnson in the room? Ms. Johnson, why don't you go ahead and get us started?
Thank you, Mr. Chairman and committee. Thank you for what you're doing today for Senate Bill 68, as well as what y'all do every day for the citizens of Georgia to make this place a better state to live and work. I'm Brett Johnson, the founder and CEO of Vertical Earth. We're a civil and construction, transportation construction company, been in business for 28 years. I reside in Forsyth County. We have about 600 plus employees in both Forsyth and Effingham counties, and also down in Florida. In the spring of 2023, one of our lowboy trucks and trailers was transporting equipment across the top end of 285 near the intersection of Georgia 400. If you remember back at that time, that intersection was under construction, and the traffic that day, like most days, moved it more like a fast food drive-in than actually an interstate. So our truck was easing along through that area, and another car merged in front of our truck at the low speeds. From the dash cam footage, it's hard to tell that there actually was a collision. We don't know exactly when it was, but apparently those two vehicles touched, my truck and that other car. The driver of the other car flagged down our truck and motioned over to the side. They called the police. Police wrote up a report. No injuries at the scene. Both cars drove off, and that was the end of it that day. In the coming weeks, we received a damage estimate for the car for $4,589. Relatively small by today's standards, and our carrier processed the claim. 6 months afterwards, we received a demand letter at our office. I was surprised to read that the attorney demanded we immediately pay $540 million. 9 figures for an incident that didn't involve any injuries at the time of the collision, and the car could be driven away. It could possibly argue the collision was actually caused by the other car even. This is 120,000 times X of what the actual damages were to the car. For whatever reason, our society's become desensitized to these large numbers, and they're very commonplace. We don't operate a billion-dollar company, and we cannot purchase excess coverage anywhere near these limits at any price, nor we should really need to. With this type of risk, we're forced to make business decisions about which counties we work in, which type of projects to pursue, and whether to even attempt to expand services to our clients because of these increased risks. And this type of minor accident could be the end of our entire company, as well as the careers of all 600 of our employees. Regardless of how this claim is actually resolved, the fact that it was ever levied in any amount has cost hundreds of hours of our time and our staff over the 2 years it's already lingered. It's placed increased reserves on our insurance policies and caused my insurance policies to increase in value, which I then have to pass along to our customers, one of which is Georgia Department of Transportation. I agree and appreciate the need to allow everyone access to justice. Unfortunately, the scales have tipped to a point these outrageous demands are not vilified but commonplace and actually celebrated on billboards and websites, and instead endanger the careers of all of our employees and our entire company. I urge you to pass Senate Bill 68 as is currently written, and also provide justice for all of our hardworking employees and their families. And that's pretty good timing. And this is just a couple of pictures there. You can see.
Well, you timed your comments perfectly. Thank you. You have no questions.
Thank you, sir.
And you got these materials for us to hand out to committee members? All right, Deborah Moses and Zach Matthews, you're on deck. Good evening, Ms. Moses, when you're ready.
Thank you so much. I appreciate the opportunity to be here. I am Deborah Moses. I'm the Chief Risk Officer for Piedmont Healthcare, and my comments today will really be focused primarily on professional liability, both claims litigation and the insurance implications arising from that. I will tell you, while I won't spend time talking a lot about Piedmont, I'll hope that you'll have some appreciation for our status in the state, but we do employ over 40,000 Georgians, and approximately 80% of Georgians get some degree of care from Piedmont Healthcare. So what's good for Georgians is important to us. We take a lot of pride in our the quality of the care that we provide. Having said that, we recognize that from time to time errors occur. And in the risk area, I think we have 2 jobs to do whenever that occurs. First, we need to learn from it. we need to understand why it happened, and we need to take steps to prevent future harm. And then the second thing we need to do is make it right with the patient and or their family. And we're committed to that, and that's why I've spent over half of my professional career with Piedmont Healthcare, because of that commitment to do the right thing. We remain committed to do that, but I will tell you it's harder and harder to do the right thing because of the unfair litigation process that we have in Georgia. And I want to explore that just a little bit. I'm here specifically to talk about phantom damages. I think that's a key to the unfair situation we find ourselves in. It's been pretty well discussed today, but I'll repeat that under current Georgia law, patients can put a medical bill in front of a jury and act as if the full bill was paid, even when that is a fallacy. And it is always, frankly, a fallacy. And we've heard a lot about collateral source and getting the benefit of the medical insurance that maybe some Georgians purchase. But I'll tell you, this is coming into play even when there is no insurance purchased. We're still being put on the hook for our own bill, which we weren't reimbursed for at all, but it will be put in front of a jury as though 100% was paid. It's a very unlevel playing field. And, you know, we've heard a lot today about how smart jurors are, and I certainly agree with that. I also think they're trying really hard to do a good job, but they need the accurate information to do that with. I think it's ironic that every single witness that takes the stand in a trial has to swear to tell the truth, and the trials are very fact-driven, but this is one area where a medical bill is submitted into evidence, and it goes back into the jury room, and everyone in that courtroom except the jurors know that that bill is not accurate, but yet we condone that and we base damages on that. If I could have just a couple more minutes, please. You know, what impact does this have on Georgians? It is driving up insurance premiums. I can tell you that while Piedmont has a great experience from a claims perspective, our insurance, our professional liability, commercially purchased insurance has increased by 270% since 2018. And how does that impact Georgians? Well, you know, we do serve 80% of the state, and as a not-for-profit, we're investing back into those communities, and Georgians are much better off with us rather than spending that money on increased insurance premiums and insurance claim costs. They're much better off with us putting in MRIs, expanding emergency room access, buying state-of-the-art Da Vinci robots, recruiting and employing more physicians and nurses to provide that health care. So I think it's a fallacy to suggest that Georgians aren't experiencing this, and that this is a bill that is really focused on insurance alone. What we want is a fair playing field, and the first way to get that is to eliminate phantom damages.
Thank you. You have a question from Wood Park.
Thank you, Mr. Chairman. I know you're here to talk about phantom damages. You know, I've read some studies saying that, at least per analysis of Texas, adoption of caps on non-economic damages does not reduce, but may actually increase healthcare costs. I'd love to see if you have any studies or analysis that would otherwise rebut that claim. I am concerned, especially as we're focusing on Section 7 today, of some of the claims as well as some of the information I've received that patients, especially those who are uninsured, those who are on Medicare or Medicaid, would only be able to receive catastrophic care under this legislation. Can you better help me understand Section 7 and the impact that this legislation would have, especially on our underinsured and our uninsured population?
Well, the first thing I would say is, you know, we employ thousands of providers who are providing that uninsured care, who are providing care for Medicare and Medicaid patients, and it's not going to impact the care that they receive. I don't understand that argument. I may not be the best person to address that, but I see no evidence that that would be the case. With regard to your question about Texas, what I don't have studies. What I have is real life experience. We live this every day, and we're trying to resolve cases for a fair amount every day. You know, we did hear some comments that, well, the reason they should be able to put the full bill in is because they have to hire a lawyer to get a recovery. That's also a fallacy. I can speak for Piedmont Healthcare and say, if we owe you, we're going to pay you whether you have a lawyer or not, and we're going to pay you a fair amount. We've got a long experience with doing that, and we have patients that leave happy because we've treated them fairly. So I don't have studies. I know we heard from the law professor from New York, and that this has no impact on tort reform. The only thing I can tell you is severity in professional liability claims. I think we've heard some testimony today that there is no increase in severity, or Georgia's no worse than any other state. There is independent actuarial analysis showing that in professional liability claims, Georgia outpaces the rest of the nation 2-to-1 in the severity of claims in the last decade in the professional liability space. And it would be naive, I think, for any of us to believe that that's not driving up insurance premiums.
If you could share that study with us, I think that'd be greatly appreciated. Now, again, especially for those who support this bill, I'm very concerned in terms of the potential impact this may have, again, on Medicare, Medicaid, and otherwise uninsured patients. And so certainly appreciate your testimony and all the good work that Piedmont Healthcare does. So I'll leave it there. Thank you.
Okay, thank you.
Thank you. You have no further questions.
Great, thank you.
Oh, wait, I'm sorry. My fellow doctor practitioner.
Thank you, and thank you to all your team and the 40,000. They're doing great work across a large part of Georgia. Just two kind of quick points. You mentioned insured and uninsured. Do you know if y'all have a discount program for people who are uninsured, and if so, do you know a ballpark of about how much that would be?
Across the top, uninsured get 30% discount, and then often it's written off more. And the same goes for self-pay. Well, let me say, it's the same thing, and but for us, it's two different. There's self-pay who have the ability to pay, okay, and then there are the uninsured that don't. So self-pay immediately get 30% written off, and then there may be further negotiation. Uninsured, more times than not, that's going to be a write-off.
Thank you.
Yeah.
Thank you. Zach Matthews, and then Charles Tarbutton, you're on deck.
Good afternoon. My name is Zach Matthews. I'm with McMickle, Curry, and Branch. I have a little presentation here if I could just bring this up. We primarily defend truck wreck cases with the occasional catastrophic injury case in the negligent security space. Yes, sir. What I did was yesterday I reached out to one of our clients to get a quote on the commercial auto rates for one truck or commercial auto in Alabama versus Georgia. As of yesterday, insurance in Georgia is 32 to 40% more expensive than in Alabama. I actually had a conversation with my eye doctor on the way here. I had to go by the eye doctor. And I asked her, do you have a commercial auto for this eye clinic? She said yes, for our employees to drive. It's not just big trucks. Why are insurance bills higher in Georgia? Where is my extra insurance money going? One of the things we do is litigate a lot with litigation-based medical clinics. There are specialty clinics we call lien clinics that basically just do lawsuits. In discovery, we have been able to get information from them about how many of those cases they are doing. This is one example from a North Georgia lien clinic that in 3 years took in 29,340 patients from lawyers. The lawyers are on this list. They're redacted right there for their courtesy, but practically every law firm that does personal injury work in Georgia participates in this space. That clinic billed those 29,000 people $231 million in 3 years. They collected $51 million. Fewer than 0.001% of those charges were routed through health insurance for those plaintiffs. This is real data. This is not hypothetical. It's right there. That's from inside the House. This is data on how many Georgians have insurance by category. 11.4% of Georgians are uninsured. I would challenge you to walk around and find 29,340 people who don't have insurance out of the 11% of this population walking around these streets. It's impossible. They are convincing people not to use their insurance. And that's driving them out of the healthcare system and out of the structures the healthcare system has to govern these procedures. One of the things that one of the doctors testified to earlier was that Medicare and Medicaid doesn't pay reimbursement for certain procedures, so there's nothing to compare to. That is true. Medicare and Medicaid doesn't reimburse for snake oil either. They don't reimburse for procedures they don't believe are medically necessary. So part of the problem is when you take people out of health insurance, you're taking the referees out of the game. No one is checking to see if these procedures are necessary or medically indicated. The same liability insurer that gave me that rate quote is currently losing 28.9% per year in Georgia in auto. Those of you that run businesses know if you lose almost a third of your money a year, you're not going to stay in business very long. They do make money in other spaces, but this is a space that they're not going to be able to turn a profit in this state. These are real pictures of real injuries that we've seen, almost done. $1 million demand, no damage. $1 million demand, bumper tap. $1 million demand, no damage. $1 million demand, $800,000 in medical expenses with no damage. We have testimony from citizens of Georgia saying that they have been convinced to go off of their insurance and accept injections to drive up the value of their lawsuit. And we have emails from inside the House between members of the Georgia Trial Lawyers Association and Lean Clinic saying, quote, there is a $1 million policy on the other side in all caps. I gave this info earlier. She wants to end treatment, and I wanted her to continue. At the end of the day, this is about money. The policy premiums that people are paying in Georgia are going to line the pockets of people that are specializing in this space, and it's an easily correctable problem. This bill will correct that problem, and it should be passed.
Thank you. Representative Evans.
Thank you, Mr. Chairman. First, could we have these slides and any of the background information? I mean, you kind of flipped through that really quick and said there's all these medical damages, but we don't have any.
Show me which slide you'd like me to show.
It's anecdotal, so we don't have any, we don't know, right? We don't know any details about what actually happened in these cases.
You want to swear me in?
Well, I wish I could, but do you have some actual data that you can share with us other than this summary PowerPoint?
This data was produced to us in discovery in an actual case.
Can you give us
I certainly can.
the production?
I don't know that I want to do that. I don't think it would be very
well, you gave us the
respectful to them.
summary,
Yes,
so
ma'am.
we can't have the background facts?
If you want to send an email to my office, I'll see if that can be arranged.
I
I'll reach
will,
out to their counsel.
and you can leave it with me before you leave. I want to go back to where we started, though. You showed this quote from a Georgia carrier and an Alabama carrier. Were you aware that drivers on the street in Georgia are more than twice as likely to be in an accident than they are in Alabama? Don't you think that might have something to do with the rates?
Yes, ma'am. That's a fair point. You're pointing out that Georgia's got a lot of people, Georgia's got a lot of traffic, Georgia's got a lot of wrecks, and that's true.
A lot of highways.
That's true, but this is by percentage. This is by percentage.
No, but
so why should it be more expensive in Georgia by percentage than it is in Alabama? It doesn't make any sense.
Because you're twice as likely to get into an accident here, and the rate, the difference of what Georgians pay is not that much more than they pay in Alabama, considering they're twice as likely. That should probably be double if we were going on percentages, right?
I don't know that I follow that math, but even if that were true, it still doesn't make sense that an insurance company would be losing this amount of money a year. I mean,
well, and that was my next question. Where's that information? Who is this liability insurer, and where is the data that we can look at to say that they're losing 28.9% a year?
They were generous enough to share this with me, but they asked me not to use their name, and I'm going to respect that.
So there's no way we can fact check anything you just told us? We don't know who it is. We don't know what 28.9%, where that comes from. We have no idea, right?
That's true. You can accuse me of lying, and I'll take that. Yes, ma'am.
Well, I'm not accusing you of lying. You don't know you can't know what they told you is true. They didn't want to give their name.
Yes, ma'am,
they didn't want to give any background.
No, they showed me the background data. I put the math together for you.
Well, can you share it with us?
No, ma'am.
Thank you.
I'm sorry, I just had a, thank you, Mr. Chairman, just had a question about your 11% Can you go back there? Okay. So you're saying that 11% of Georgians are uninsured?
This is not me saying this. This is publicly available data, but that's my understanding. Yes, ma'am.
Okay. And so I guess my question is, what is that number and who composes that number? Like, what is the actual number of it, and then who's in that number?
Those would be people who are not being provided with insurance by an employer, by a federal government program like Medicaid or Medicare, which is split out in the chart, by military. There's a small percentage of military insureds, and then non-group insurance is just kind of a catch-all category. Those are people who don't have health insurance.
Yeah, but I mean, I guess that my question is, the percentage is smaller than, I guess, other folks, but like, what is the number, and then what is the correlation of that to the folks who went to this clinic? I mean, it seems like you're trying to make a point with that, and I didn't get it.
Yeah, okay, I'm sorry. There are 11% of people walking around who don't have health insurance. So if you go out in the room and you count 100 people, you should find 11 of them who are uninsured from the population of Georgia. This clinic managed to gather up 29,340 people for a 3-year period to treat, and none of them had health insurance. I don't buy that. That's not possible.
Is it that they don't have health insurance, or they elect not to use their health insurance, or is it that? So that's what you're saying?
Yes, they are electing not to use their health insurance. Yes, ma'am.
And you know that for 29,000 people, that's what you're representing?
That's not what I'm representing. That's what their data shows. I can show it to you.
And
out of $230 million charged, their insurance receipts total was $27,000. That is 0.001%.
Okay. And so I guess my question, well, I'll say this. There are some people who have car accidents who are not at fault, who don't want to make a claim on their own insurance. If a person pays for insurance, isn't their right to use it or not use it? Like, I'm just trying to follow your point on this.
No, I think you make a very good point. I think if that same person was willing to come into a jury and tell them the truth about what their damages are really worth on the open market, then it would be okay for them to say, I don't want my insurer to have to pay that. But when they elect not to use their insurance, and then they try to use that as a lever to get the full 100% charge master in at trial in order to inflate their own damages and inflate the damages of the people that have treated them on a lien, I do have a problem with that. I don't think that's right.
All right, thank you. You have no further questions. All right, Mr. Tarbutton and Vicki Lewis, you're on deck, ma'am.
Just trying to turn this off for you, sorry. All right, hold on, Ms. Matthews, if you come back 1 second.
I was just going to find your email on the bar website, but I typed Zach Matthews and I didn't see you. Could you just tell me your email address?
zmatthews@mkblawfirm.com.
2 H's? I mean 2 T's?
2 T's, yes ma'am.
zmatthews@
mkblawfirm.com.
mkblawfirm.com. Thank you.
No problem.
All right, Ms. Tarbutton.
Good afternoon, Mr. Chairman and members of the subcommittee, and thank you for the opportunity to come here today, and thank you for your service. My name is Charles Tarbutton. I am the president of BH Transfer Company based in Sandersville, Georgia. BH is a 54-year-old family-owned trucking company that primarily serves customers in the southeast United States and internationally through the ports of Savannah and Charleston. We provide good jobs and financial security to 325 families across about 24 counties in middle and southeast Georgia. In addition, I currently serve as the chair of the Georgia Motor Trucking Association. There are over 335 Georgians employed in trucking, 1 in 12 jobs statewide. We are as diverse as any industry in America. We live in every House district, and we vote. Let me be clear. Our industry's top priority is safety and compliance. There are bad actors in every industry. That is why regulatory oversight exists. There are injured parties connected with every industry. They deserve to be made whole. Our industry is committed to do the right thing by those injured by a commercial vehicle. But our industry is overwhelmed by frivolous lawsuits with claimants that have no demonstrable or verifiable injury with collisions from collisions in which physical damage to vehicles is minor, if it exists at all. I am here today in support of SB 68 and specifically in favor of changes to the so-called phantom damages. Phantom damages are inflated economic damages calculated using the dollar amount a patient is billed for medical services instead of the amount actually paid by the patient or his insurer. In fact, very few patients actually pay the full billed amount, as you have heard from others this afternoon. And the actual payments to providers generally range from 1/4 to 1/3 of the full billed amount. Claimants should be made whole and recover economic damages equal to their actual cost, but not an inflated artificial amount that they have not actually paid. General or non-economic damages are typically a multiple of special or economic damages. We have a current case where a claimant alleges $50,000 in medical costs and has demanded $400,000 to settle the claim. The total demand is 8 times the asserted economic damages. Let's assume for a moment that the plaintiff actually paid 50% or 25% of the full billed amount instead of the significantly lower range that I referred to earlier. Still, the 8 times actual economic damages would yield a demand of $200,000 versus the $400,000. This difference, excuse me. Having computer problems, it seems. The total demand is 8 times the asserted economics. Excuse me. The difference between the billed amounts drives up the cost of the non-economic damages.
Mr. Hartman, if you could try to close for me.
Yes, sir. I would just say that phantom damages are an artifice, and all we are asking for in what we support in Senate Bill 68 and the phantom damages section is the admissibility of the actual paid damage that sets a floor, and the full billed amount sets a ceiling for the jury to consider as they determine damages. Thank you very much.
Thank you. I don't see that you have any questions. Ms. Lewis and Dr. Patrice Walker is on deck.
Mr. Chairman, members of the committee, I'm Vicki Lewis. I'm the president and CEO of Coffee Regional Medical Center in Douglas, Georgia. I'm here today to encourage your support for healthcare liability reform. This reform is essential to our hospital. We are a 98-bed acute care hospital in South Georgia. In addition to serving our county of 44,000, we serve 6 nearby counties, some of which have critical access hospitals and some of which have no inpatient services. We provide obstetrics, cardiology, oncology, and general surgery. We have a very, very busy emergency department and bring patients, again, from a pretty wide geographical area. We're about the polar opposite of Piedmont. But we care for all patients regardless of their insurance status or their ability to pay. In 2024, we delivered 1,000 babies. We saw 52,000 people in our emergency department and our walk-in. We cared for over 8,500 oncology patients, and we performed 4,000 surgical procedures. Again, pretty remarkable for a county of 44,000 residents. Our services are essential and foundational to our county and our surrounding communities. We know that a strong hospital is part of the economy, and we take that responsibility very seriously. There are two primary challenges Coffee Regional faces every day: the recruitment and retention of talented physicians and staff, and operating with a positive bottom line. The tort environment in Georgia is a challenge to both of those. Certainly, our payer mix and our rural location bear on these challenges, but the continuing increase in costs for medical malpractice, including defense and insurance and premiums, bring a significant challenge. We believe, like other hospitals, it's our responsibility to have appropriate insurance, and we have a deep understanding of patient care. None of our caregivers or physicians come to work every day to harm anybody. Our care is to, we want to do what's expected, and we believe in a patient's right to file a lawsuit if something unexpected happens. But we also support hospitals and physicians' ability to care for their patients in a safe and calm way, and we do everything we can to support our physicians. Several years ago, we pivoted to self-insurance because we couldn't afford our premiums, and we also established a self-insurance pool. Despite our efforts to control our costs by doing this, we have experienced dramatically increasing cost of defending the hospital and our physicians. Since 2024, Coffee Regional's excess coverage cost has increased by $3.5 million. I just have a couple of more things, if that's okay. So this is not our insurance premium. This is the excess coverage that we have to buy that sits on top of our self-insurance fund. This is multiples of the bottom line that Coffee Regional Medical Center is able to earn each year and experience. Our excess coverage carriers tell us the reason for the increase is, as you've heard before, not related to the experience in Coffee County, but rather the verdicts and settlements throughout Georgia, including the number of cases exceeding $10 million. It's challenging to avoid passing these costs on to our patients. Last year, we had a physician who, after a long career in a high-risk specialty, decided, along with his lawyers, to take a case to trial. They had tried very, very hard to settle the case for a fair and reasonable amount. They were not able to do that. They decided to take the case to trial, and unfortunately, several things happened in that trial that have been described today as well. The jury was prevented from knowing how much plaintiff and plaintiff's insurer actually paid for medical costs and what the balance to the patient was, leaving the jury with a very inflated impression of the cost. And the jury was also presented with an artificial dollar amount for pain and suffering, completely unrelated to the patient's care. The jury awarded a very inflated amount to plaintiff, and unfortunately, after that, our physician made a difficult decision to step away from medicine. It was very deflating for him and discouraging. That jury decision also impacted other physicians on our staff and their decisions about whether to settle a case or to go to trial. And I think that their confidence, too, in their own medical care was impacted. So we've attempted to recruit and replace this physician for 18 months and not been able to do that. Our mission at Coffee Regional is to provide exceptional care and wellness close to home. It's a challenge for many South Georgia residents to travel outside South Georgia to receive care. We don't want to stop providing specialized services, especially when significant numbers of our community need it, but we certainly contemplate that every day. I believe with the legislative support of Governor Kemp's reform package and Senator Kennedy's Senate Bill 68, healthcare liability costs will indeed be reduced, and I'm confident Coffee Regional Medical Center and our colleagues at other hospitals will be provided with the opportunity to continue to operate as full-service hospitals serving our patients and communities. So I urge your support of this important legislation. Thank you.
You have a few questions. What part?
Thank you, Mr. Chairman. Mrs. Lewis, first and foremost, thank you so much for all of your incredibly important work, especially in serving the patients of South Georgia. Again, with respect to Section 7, I'm trying to get a better understanding. If Section 7 resulted in Medicare, Medicaid, and uninsured patients receiving only catastrophic care and being forced to only go to emergency rooms, Would you want to see amendments to Section 7 of this legislation?
I can't speak specifically to Section 7. Again, our mission is to care for all patients, regardless of their ability to pay, regardless of how they enter our system. So we provide care on an ambulatory basis and obviously in an emergency department. We also staff an underinsured and uninsured clinic in our community where patients can come for care.
Thank you. Greatly appreciate that as well. One additional question. Would you be able to share how much in uncompensated healthcare costs you currently have and how that contrasts to your insurance costs?
Can you ask the question a different way?
We have uncompensated healthcare costs, right?
Understand.
And certainly, it sounds like y'all are serving a lot of those patients who have no health insurance whatsoever. At least with respect to Piedmont, they simply write them off. I'm trying to get a better understanding of how much for the hospital associations, but for y'all as well, how much are your uncompensated healthcare costs?
For every dollar we bill, we collect 22.5 cents.
Okay.
So we have a significant amount of uncompensated care. Again, that's directly related to the number of patients we care for that are uninsured and those that are underinsured. So it is a significant amount of money. We are about a $600 million operation from a gross standpoint and a $170 million operation from a net standpoint. So you can see the impact of what we're doing is very difficult. So our uncompensated care is significant.
Absolutely, and I've certainly worked on various proposals to cover our uninsured population to help address those uncompensated health care costs. How does that then compare to y'all's rising insurance costs?
I think there's a direct correlation. I think that the rising insurance costs are a function of unfortunately the costs that we have to pass on to our patients. We allow for that because we care for patients no matter of their ability to pay. So it's every commercial contract we have is a discount off billed charges, or we have a contractual rate that is a small percentage of our charges. We work very hard not to inflate our charges because we know that our community cannot pay those. But I think the 22.5 cents speaks for itself.
Thank you.
You're welcome.
Thank you, Park. Chair Lady Miller.
Sorry. Thank you, Mr. Chairman. I want to ask a question because I'm still struggling to understand some of this billing stuff. Not an expert in it at all, but if a patient has a procedure in the hospital, it's $100,000. In the facility, it's $100,000, but they don't use their insurance. Do they owe $100,000, or do they owe only what their insurance would have paid? So let's say, for example, $25K.
Okay, your question's confusing. Does the patient have insurance or not have insurance?
The patient has it, but let's say they don't use it in my hypothetical. So the insurance is not billed. Patient has a procedure. The procedure costs $100,000, but if the patient had used their Blue Cross Blue Shield or whatever, it would have been essentially a $25,000 bill. What number of that would the patient owe? Would they owe you the actual $100,000, or would they owe you the $25,000 that you would have gotten if the patient had used his insurance? Does that make sense?
Not exactly, but
Okay.
I'll try to address the question
Okay.
anyway. First of all, if a patient has paid for insurance and has insurance, what our financial counselors would do is to encourage that patient to use their insurance. It's a premium they paid, they have it, they've qualified for it. So we would encourage them to do that. If a patient doesn't have insurance, they do receive a discount as a cash, if they pay cash over time or in a lump sum. But again, we write off a significant amount of our care because of patients who don't have insurance. I really struggle sometimes, and I know there have been some examples here with patients not using coverage that they have. If the premiums have been paid in part by them and in part by an employer, obviously it's coverage they have, and so they typically use it. balance bills are often also written off. So again, if a patient's insurance company has a discounted off-bill charges kind of summary and the insurance pays a portion of that, we try to work out, payment plans with patients, and oftentimes those are written off.
Is there ever a situation, and this may not happen, but I just want to understand, is there ever a situation where a patient shows up, patient goes to ER, for example, or is admitted, patient's insurance is not billed, patient then is involved in litigation over their injury, and it's a $100,000 bill. Does the hospital benefit more? I guess what I'm trying to ask, are there situations, or are you aware of situations where hospitals do not bill the insurance because getting a settlement from the lawsuit will actually be more money than billing the insurance?
Never.
Okay.
Thank you. Representative Evans, you have a question?
Yes, thank you, Mr. Chairman. Thank you, Ms. Lewis, for being here. A couple of questions. One, you were telling us that the excess coverage costs went up by $3.5 million since 2024. What's the total that y'all paid for excess coverage since 2024?
Oh, gee, I don't know if I can add that up. I can't give you that number. I can get it for you. Again, it's gone up from $550,000 in 2014 to $4 million in 2025. But I can give you the total cost there.
So this is over okay, I wrote down since 2024, so we're talking about a 10-year.
2014 to
2014.
2025. It's a 10-year period.
That's the increase. Okay.
And I apologize if I misspoke.
Okay, 550,000 to 4 million.
Yeah.
Okay.
And again, that is excess coverage.
Sure.
That's over and above premiums we pay, or money that we set aside in our self-insurance fund.
Right, and you mentioned that one of the reasons, I can't remember if you said the carrier told you or you assumed that one of the reasons for the increases has been litigation costs. Was that something you assumed, or was that something the carrier told you?
That's what the carrier told us.
Did the carrier tell you any other reasons why insurance rates were going up?
I think the Georgia environment, the total number of lawsuits that have been filed. I mean, our own experience is that over the past 10 years, and I'm using a 10-year time frame because that's the length of time I've been at Coffee Regional. Over the past 10 years, the number of lawsuits filed annually has increased steadily.
And do you have those numbers for us, the increased number of filings? Or did the carrier provide it to you?
So the lawsuits filed?
Yes.
I can get those
Okay,
for you.
that would be great. And then, but my question, I want to go back to it, was did the carrier give you any other reasons for the increase? Are you saying that the carrier said the increased costs were just because the number of lawsuits filed were going up? Or was there any other reasons that they gave?
Yes, there were other reasons that were given.
What were those?
I think they're varied a little bit. One of the reasons is the attachment points in the policy. Because of our exposure and the number of lawsuits filed, we paid an extra premium to bring those attachment points down.
Anything not related to lawsuits that the carrier said was part of the reason for the insurance increase?
No.
That just lawsuits?
Not given to us. Again, I'm not saying that there might not be other reasons, but those were not shared with us at the time that we were renewing our policy.
And who is the carrier?
MAG.
Okay. And you also, I think you were saying, I want to make sure I heard this right, you believe uncompensated care is probably part of the increase as well. Did I hear that right? Maybe I didn't.
No, I don't think you heard that correctly.
Okay.
I don't think uncompensated care is related to it. Again, I think the number of lawsuits, the amount of the settlements, the risk. I mean, the actuaries are obviously the ones that run the math on what the premiums are going to be for us. But it's not just our experience that drives those premiums. And we've been given pretty clear information about that. That is a Georgia-related experience.
And we can get that data that you had that's pretty clear. You could share that with us?
Again, I only have that for our premiums.
Okay.
So.
Right, but that's fine. You also said that someone had told you the number of cases exceeding $10 million was part of this reason. Do you have that data that you can share with us as well?
We do.
Okay. Do you believe that, well, I know recently y'all have done a great job having to deal with the aftermath of Helene and the extra care, I'm sure, that was required for that. I know y'all had problems with power and water and other things, right?
We did.
And that was not the first storm that y'all had to deal with, right?
It was not.
How many would you say over the last 10 years, major storms where you've had similar sort of, I mean, this one was a pretty bad one, but how many do you think?
I mean, 3.
Do you think
so not every year by any stretch, 3.
Do you think that any of those storms had anything to do with the increase in coverage?
In medical malpractice?
The excess coverage, anything, any of your insurance costs?
You know, I'm not sure that I can really comment on that. I don't think I have the information to comment on that. I'm not sure that's a line I could connect.
Okay. Let me just make sure I had written some notes and now I can't read my own handwriting. Well, I think if you could just follow up with us and let us have the same data that you have, that would be appreciated. And if we need to get it from MAG, we can do that too, because I'm assuming if they provided it to you, maybe they provided it to others.
Again, they provide it to our hospital like they do others, particular to our experience. The number of cases over 10 million is available to us through our self-insured captive.
Okay. Well, wherever it comes from, if you could get that to us, maybe this week, that'd be really appreciated.
I'm happy to share that. I'm assuming that the GHA has your contact information.
Yes, or I'll share it if they need it. Thank you.
You're welcome.
Chairman Newton.
Thank you, and just want to thank you for coming up here all that way from Coffee County and Coffee Regional. Thank you for doing that. Do you think that this bill, if you don't mind, if this bill does succeed in slowing the increases in that excess coverage and premiums and everything else, do you think that'll help you care for patients better in South Georgia?
Absolutely.
Well, thank you for being here, and thank you to your team.
You're welcome. Thank you.
Thank you, and thank you for your testimony. Dr. Walker, and Dr. Cannon is next.
Good evening.
Good evening.
I am Patrice Walker. I am the Chief Medical Officer for Atrium Health Navicent, where we have our flagship hospital located in Macon, Georgia, but we also have a critical access hospital and a small acute care rural hospital. Not only am I Chief Medical Officer, but I'm also an OBGYN, and certainly in that specialty, we have been getting sued long before it was the sexy thing for everyone else. So my perspective comes from both hats. At the end of the day, the current medical legal climate in Georgia is causing physicians to change their practice patterns, and I see that every single day in my facility. And what I mean by that is there are some things that are more subtle than others. For example, I may have a physician who orders low-value testing just to be on the safe side. I may have a physician who keeps a patient for an additional day just to be on the safe side, when all other evidence-based practices say the test is not necessary or the patient can go home. Yet we have physicians who feel the pressure of needing to do these additional things based off of their risk aversiveness. And those are just a couple of examples of what we see every day. And ultimately, these things are affecting access to care for patients, because if we're keeping patients longer for a test or a study, then that means right now one of the patients in our emergency room is waiting for a bed that I don't have to give them because there's a patient already in that bed. And so, in essence, when there is a decrease in access, people present with advanced disease or advanced disease states for things that really are preventable and could be, treated earlier. That means for OB patients, they may show up with limited or no prenatal care so that fetal anomalies or complications of pregnancy are missed. And we cannot expect to improve our maternal morbidity or mortality numbers without solving access to care in rural or underserved areas. In addition, our flagship hospital is a teaching hospital. And so my lived experience, as opposed to some of the opposition testimony that you heard today, is certainly that our medical students and our residents are including the malpractice climate in Georgia as part of their rationale for whether they will or will not practice here in the state of Georgia. Is it the only reason? No, it's certainly not. But I think it's on the list, and we really cannot ignore it. And as far as the people in this room, that's one thing that you have control over. You may not have control over the fact that they're also looking for competitive pay because they have a lot of debt. They're looking for lifestyle flexibility. They're looking for the ability to, practice the full scope of medicine. But you can and do have the ability to impact their risk as far as the out-of-pocket cost to them and their employers, like our health system. And so I really want us to make sure we don't get distracted and focus on what you do have the ability to control here, and that is, I fully support this bill, and I think that this bill will help retain physicians to practice here in the state of Georgia.
Thank you, Mr. Chairman. Thank you, Dr. Walker, for being here. I think you said, and if you didn't say this, just let me know if you agree, that people sometimes present late for, like, if they delay care, they're going to be more sick, if that's a word, sicker. And do you agree that sometimes people delay care because they don't have insurance?
That is one reason, but really my point here is that so access is already an issue, and yes, it may be because they don't have insurance, but also I think it has to do with whether they have insurance or not. Are there physicians in their community that can provide them care? So it's one thing to have insurance, that's something, but if you have to travel a long distance, if you have to miss work, if transportation is a barrier, that insurance is just one piece of what you need. So my point here is that it's more than just having insurance that affects someone's access to care. They need to have access to a physician and a clinic to get that care at.
Sure, but that's a big part of it, and we've got a lot of uninsured people in Georgia. Have you been down here advocating for increased coverage, expansion of Medicaid, things like that?
Yes, expansion of Medicaid is certainly controversial. I would like for there to be access to, coverage in whatever form. I think that can look a lot of different ways. But again, I would reflect back on having that coverage is one piece. There have to be physicians and providers to utilize that insurance.
I'm just trying to think of some of the things that are within our control, and helping people get coverage is one of those. My last question is, was right there in my brain. Let me see if I can get it back in my brain. Oh, yes. So let's go to an example where someone has health insurance. They come for treatment. You've been a doctor, sounds like, for a long time. Insurance doesn't always approve what the doctor and the patient decide is the right care. Is that accurate?
That is accurate.
And sometimes that's not super predictable, is it?
Sometimes.
And so under this bill, we're setting up the scenario where a patient is, when we're predicting future care, if they have insurance and it's possible that they use it in the future, that's going to be used to sort of calculate the damage for that future coverage, and that's not really predictable, is it? Whether it's going to be covered in the future, and if it is, at what rate it's going to be covered, and whether that patient would even have the same insurance. Would you agree that that's a lot of hypotheticals?
If I follow you, that is a lot of hypotheticals. I want to make sure I understand what you're asking. You ask that one more time. I'm sorry.
Sure. Yeah, and it's confusing. Under this framework that we've set up here in this proposed Senate Bill 68, not only is a plaintiff these alleged phantom damages, you and other proponents of the bill are asking that the amount that gets claimed for past medical damages is the amount actually paid, not the amount billed. That also is, under the framework of Senate Bill 68, supposed to apply to future medical expenses. And so this bill would require a plaintiff and their lawyer to talk about, okay, this is what we think the care should be, and this is what the cost will be if the person has insurance. And we can't really know that, can we? We can't know if it's going to be covered. We can't know at what rate it's going to be covered in the future, or even if that person's going to have the same health insurance in the future, right? Those are all hypotheticals. Yes?
Correct.
Okay, thank you.
Thank you, Mr. Chairman. Thank you, Doctor, for coming. I just wanted to clarify a thing. I thought I heard you say that it's the legal environment or lawsuits that is creating a shortage of doctors. Is that what you said, or did I get that wrong?
So I think there is a link there. No, it is not the sole reason, but particularly I can speak to OBGYN as a specialty. In our specialty, you can actually divide your practice into obstetric care and gynecologic care. And so you can choose to do both, one, either or. So what generally happens is most people start off practicing both. You're trying to build your practice. You need to get patients in, so you're seeing OB and GYN patients. Over the course of the career, particularly as you get towards the end of your career and their lifestyle is challenging, a lot of physicians choose to stop doing obstetrics, and so they are able to continue just doing GYN. I think the current climate is allowing people to make those decisions, or forcing, I would say, some people to make those decisions sooner rather than later if they can financially, afford that. And your malpractice insurance goes down once you stop obstetrics, because the bulk of the risk, not all, but the bulk of the risk comes from obstetric practice. So if you can decrease your obstetric practice or stop your obstetric practice and still practice your GYN side, you can still, make a profit in most cases and have decreased, malpractice risk. So those are the types of things that influence access to care, because if you have less OB providers, then those same OB patients have to go further out to get that OB care.
Okay, I thank you, and I think that's what you're saying is that based on your experience, because my understanding of the studies, and if you're familiar with them, you can tell me you're familiar or not, is that the rationale or the reason why these shortages are occurring it's based on a very complex number of factors. One, to include an aging population and increased demand for health care, increasing older adults require more health care, greater demand for physicians, baby boomer retirement, increased lifespan, physician burnout, healthcare workforce issues, limited training capacity, residency caps as it relates to Medicare and Medicaid, specialization. Many medical doctors choose to specialize, which can exacerbate shortages in other essential areas. Rural areas, many physicians prefer to work in urban areas, leading to shortages in rural areas.
We get the point.
Cost of medical education, student loan debt. Would you agree that those are the things that the studies have found, which are the rationale or the basis why we are across the nation experiencing doctor shortages?
So I'm not familiar with that exact study that you're talking about, nor do I disagree that it is a multifactorial issue. I don't think anyone's claiming this is the sole reason. I think it is a contributing factor, and depending on the perspective or the specialty, it may be a larger contributing factor for some than others. So, those things on your list are real things, but also this, and again, this is my lived experience, and in terms of my lived experience and the size, we're bigger than Coffee, smaller than Piedmont, but it's, we're there. And so we train over 120 residents and fellows every year. So I don't have that study, but I have what I do every single day that proves those numbers out.
Thank you. And I appreciate your experience and value it very much. My second question, which is my last question that's specific to OBGYNs, we have heard and seen reporting, and actually heard from doctors who have come down here and testified, OBGYNs who have testified, that Georgia, another reason in the complex factor for OBGYNs is that the 6-week abortion ban, which criminalizes doctors for providing abortion care and health care, has influenced the number of OBGYNs who want to come down here and practice, residents who want to do their residency here. Would you agree that with some OBGYNs and in that profession, places that are hostile to or who have these sort of criminalization of practicing medicine statutes also contribute to a shortage of doctors? OBGYN specifically?
Yes, I do, in fact. And I think I mentioned most physicians are going to want to practice at the top of their license, and that means that everything that we get trained for, we want the ability to try and incorporate that in our practice as we see fit. And so when there are practice environments that put limitations or external limitations on that, that can certainly influence someone's decision about whether or not they want to practice there. In addition to that, though, I would also add that there are, if you do choose to practice in an environment like we have currently here in Georgia, that doesn't stop the patients from coming in, and so having the additional risk of a patient who has maybe attempted an illegal abortion or who falls into that gray area, I'll say it, where the rules are very not clear, places the burden on the physician to, I want to take care of the patient that's in front of me, I want to do the right thing for the patient, and yet I'm at risk if I intervene because of some of these laws that I have to practice under. So that too also affects their decisions about where to practice and in what environment they feel that risk is worth taking.
What part?
Thank you, Mr. Chairman. Especially as a hospital kind of between the sides of Piedmont and Coffee Regional, could you speak to, again, the impact of uncompensated healthcare costs versus your insurance costs? Which places a greater strain on your hospital? If you have that information with you.
I don't know that I could say which places a greater strain on the hospital. In terms of our uncompensated care, I can tell you that for our system, we have about $248.3 million per year in uncompensated care and other community benefits. There's an other bucket, but and that breaks down to about $680,000 per day. And so what I don't have on hand is that number compared to our, the other.
Your insurance costs.
The insurance costs. So I can't tell you the balance of that between the two, but certainly it is impacted.
And again, thank you for your testimony. Again, I've also been trying to get a better understanding of Section 7. I know there's a lot of legalese in here, but if Section 7 said that Medicare and Medicaid patients could only get catastrophic care or health care in emergency rooms, would you still support this bill, or would you want to see an amendment?
I mean, like others, I don't know that I can speak specifically to Section 7. I feel like we all need to go home and study Section 7 a little bit more. Again, like my colleague has said, we want to provide care to everyone, and we will. We're not going to turn patients away. I would go back to the statement that I have already made in terms of someone simply having insurance coverage is not the end-all be-all. What we see is that is, having something is better than nothing, but ultimately there's what is the quality of that, of that insurance coverage. So to say if all they have is catastrophic insurance, is that good enough? I mean, I think that really undervalues or it really minimizes the totality of it's part of a bigger conversation, I guess is what I'm trying to say.
Without a doubt, I think any access to healthcare is better than any, including with respect to emergency room services. But of course, it's also a matter of preventative care and the health outcomes of patients, in which, unfortunately, given having one of the highest uninsured rates in the country, based on decisions that this body has made that we otherwise had control over, something to certainly address more, and again, hopefully we'll have some more information about that Section 7. Thank you.
Thank you.
Thank you. Doctor, thank you so much for your testimony. We appreciate your time.
Thank you very much.
Dr. Brett Cannon, and then Brett Johnson is next. So we're finishing up with the two Bretts.
All right. Absolutely, appreciate it. Mr. Chairman and committee members, let me thank you for the time to address Senate Bill 68 on behalf of Medical Association of Georgia.
I'm Brett Cannon. I'm a physician. I moved to Georgia in 1997 to complete residency in emergency medicine. I've been on medical staffs and treated patients across the state and currently reside and practice in the metro area. I also have a law degree and admitted to the state bar. I'm the current president of the Georgia College of Emergency Physicians and also the chair of MAG's Lawsuit Reform Task Force. Is that a bit better? All right, thank you. For more than a decade, we've been experiencing widespread and fundamental disparity in the civil justice system that has had a significant role in creating a crisis in delivery of health care, both related to access and the substantially increased costs of care. The costs have been related, at least in part, to higher malpractice premiums than found in neighboring states, and recently higher recruitment and retention costs of physicians related to the reputation Georgia has in the medical community regarding medical malpractice environment. The reforms proposed in Senate Bill 68 would have a very real impact in addressing this crisis, not only in healthcare, but for businesses and industries across the state. Over the past 18 months, MAG has studied what neighboring states have done, talked with physicians, hospitals, insurers, and legislators with the goal of finding common sense and balanced solutions. We feel that Senate Bill 68 achieves those goals and moves us closer to parity with nearby states on the issues of civil justice and still protects patients' access to the courts. And to be clear, patients and plaintiffs should have that access. There's a necessary balance, though, between adequately compensating patients in a system that is so punitive and unfair that it discourages physicians from practicing or seeing complex patients or going into high-risk specialties or moving to rural areas with scarce backup or even moving into the field of medicine and making it less attractive for our best and brightest students to pursue. I believe these bills will improve access and quality by making Georgia a more attractive place to practice medicine in than it is currently. Regarding the health of the insurance market, I can only tell you my group's experience, and that is we have a captive with a large established, respected national insurer. Based on the review of the claims history, it was determined this past December that the captive was underfunded by millions, $13 million for 2023 and $28 million for 2024. This is in excess of what was collected from policy and truly affects and threatens my practice's ability to remain viable. This is not an insurer doing well, and it's not due to investment cycles. Regarding the sections being focused on today, I would note that medical malpractice trials are increasingly complex, often employing battle of experts and complicated medical issues. Our experience in North Carolina, based on feedback from attorneys and jurors, is that there's a significant benefit to such complex cases in separating issues of negligence and damages. And truth and damages is particularly relevant for any trials dealing with medical bills. We all know that billed amounts and paid amounts widely differ, and there are discounts applied for insured and uninsured alike. There's no logic to using an amount that everyone knows is artificially inflated and rarely, if ever, collected as being a true measure of damages. I'd also like to touch briefly on anchoring, having witnessed it in trials and seen its effectiveness. It's a powerful, manipulative tool and very difficult for defenses to rebut, as there's a risk in confusing or offending the jury when suggesting low values to counter the high. I'd like to, if I can, 30 seconds just to touch on two anecdotes, and that is, as the previous speaker noted, that for years we've had physicians that I'd interview and they would ask about MRIs and CT access and cardiac caths and nursing staffing, but several years ago that switched, and the questions are not only about Georgia's malpractice environment in general, but specific cases. The SSRI case that was worth $20 million, the tooth that was worth $50, the cast case that was worth $9. And just yesterday, when the appellate court confirmed a $75 million verdict against the radiologist and emergency physician, it wasn't 2 hours until I got a call that was a potential hire that was concerned about that. The second and final point is that as damaging as the trouble retaining and recruiting physicians, it's also the attrition of our more senior, experienced physicians, including doctors like myself, who would love to continue to see patients for at least another 10 years, but who struggle with that decision given the ever-present risks. Dr. A is one such physician, one of my prior partners who took very good care of a patient 6 years ago on a weekend night shift, collected relevant information, examined, performed tests including CT scans, consulted neurology, and admitted her to the ICU. Her total length of care lasted approximately 3 hours. The patient did have a bad outcome unrelated to the care, and despite the fact that the doctor delivered excellent care, for 6 years through her attorneys she received letters suggesting that she would end up, and I want to quote for a second, having to declare bankruptcy, suck up personal and professional pain and embarrassment from such a public verdict, and be prepared to sell her house, cash out a retirement fund, and declare bankruptcy.
Well, thank you. You have a question.
Thank you, Mr. Chairman. Thank you. It was Dr. Cannon, right?
Yes.
I want to give you the credit of that, Doctor.
Very
I think
kind.
one of the great tragedies in life is that we don't, even though lawyers have a Juris Doctorate, we're not called doctor. Maybe we can pass a law. But Dr. Cannon, thank you for being here. You were talking about your carrier having this underfunded, not in a good financial situation. Is that MAG?
No,
Who is it?
it's Curie.
I'm sorry?
Curie,
Curie?
Curie, C-U-R-I.
C-U-R-I. And they're based here in Georgia?
They're based in North Carolina.
Okay. So they write coverage here, other states?
They're a national carrier. Recently, they merged with Constellation, which was another large carrier out west. So they are, I believe, in all 50 states.
Okay. So they're going to be affected by things that are going on in other states, not just Georgia.
But specifically referring to the captive that we have with them in that cell, that is only Georgia policies.
Captive meaning?
That means a self-insured fund for insurance.
And if we wanted to follow up and get some more, because I'm not as familiar with them as I am MAG, we could follow up with your office?
I'd be glad to.
Okay, thank you.
Yes.
All right, Whip Park.
Thank you, Mr. Chairman. As a lawyer and a doctor, can you help me understand Section 7? I mean, it's in the bill, and so, you know, the concern
is there a specific question, I guess, would be my...
Will Section 7 result in Medicare and Medicaid patients receiving only catastrophic care or having care only in emergency rooms?
I don't believe that Section 7 would alter those federal funded programs, those patients, their access or what they currently receive now.
Say that again.
So that I don't believe Section 7 fundamentally changes the access to care that patients with those federal funds, programs, CMS and the state, currently have access to.
Certainly, you know, with respect to compliance with federal law, but I think the effect of Section 7, the concern I'm raising is that it pushes more of these individuals based on how this payment is structured with respect to plaintiff's insurance policy being provided as opposed to the defendants, with respect to how costs would otherwise be provided for. You know, that's the understanding that I've been provided, and so I'm just trying to get as much clarification, especially if this is going to harm the most vulnerable among us.
The patients with Medicare and Medicaid have a certain amount of, they have coverage, they have access to physicians that participate in those programs. I don't see how Section 7 changes that.
So, you know, throughout this hearing, and I'm not a trial lawyer, but, you know, I've been hearing and learning that there's no causal link between tort reform and lowering insurance rates. But in fact, of course, we've seen in states, Medicaid expansion states versus non-Medicaid expansion states, lower health insurance premiums for citizens in those states that have expanded their Medicaid population, whether through public or private health insurance. Is it not also true that medical malpractice insurance rates are lower in states that have lower uninsured rates than in states like Georgia that has not taken action to cover its uninsured population?
I haven't run that raid and I haven't seen that, so I don't know. I would say that my experience and my group's experience, and we practice with partner hospitals in 17 different states, is that states that have passed tort reform, and that's in North Carolina, that's in Florida, that's in Texas, that was in our experience in Georgia back in 2005, those states have lower premiums.
Well, I know Georgia's passed many different tort reform type pieces of legislation. I think what we have before us in SB 68 is a whole nother ball game. But to take all that aside, again, you know, if you could provide additional information as to what is the primary driver or one of the larger contributing factors to higher medical malpractice insurance rates, that would be helpful for my own understanding, in which a lot of the studies that I'm reading is that it's the uninsured population in which, you know, defensive medicine is more practiced, where you have larger uninsured folks that you're serving. Things of that nature, as opposed to, again, you know, this tort reform notion, very broad term, in which ultimately a lot of studies are saying there's no causal link.
I would just, again, from my personal experience and as an ER physician, patients come to see us 24 hours a day, 7 days a week. I truly don't know what their insurance status is. It's not on the EMR. I guess I could go look it up or ask them, but To me, I'm truly agnostic in terms of what they have for insurance. I'm going to take care of them the same way every time. And so that doesn't factor in terms of the care they receive or the defensive medicine or anything like that. Now, I will also say that, from the Georgia experience that our group has, and as someone who sits on the claim committees and having, the new information again as of December to look at how far behind those captives are, it's the trials, it's the cases, it's the verdicts. There's not, I'm sure you could come up and is there some percentage or some small amount, but week in and week out, we are faced with cases where the decision to settle is not motivated by feeling that care is delivered well or poorly, but is truly on the outcome, and it's the math. And the math is such that if you look at the maximum verdict or the scary verdicts that are out there, the extinction verdicts that truly would interrupt our ability to practice, and you multiply that by the percentage that the plaintiff wins, even if you think it's a very defensible case, these $20 and $30 million verdicts by a 10% is just, it's too risky. And those settlements have gone higher and higher over the last 5 years to the point where it is certainly affecting our captive and other insurers' ability to keep up.
Last comment, at least per the math and the information that I've been provided, payout per physicians have been roughly flat since 1992 to 2003. So again, I'm trying to get a better understanding as to how best we as a legislature, what actions we could take to address some of these really significant challenges, in which I think more than anything, it is our large uninsured population that continues to drive a lot of these challenges.
And if I could just briefly respond, I would say, number one, our experience with our group is that they haven't been flat, that we have seen increases. The second thing, and this gets back to kind of our difficulty with recruiting and retaining, Georgia is a net exporter of medical students, it's a net exporter of residents, and it's certainly not the only issue, but in more often than not, it is an issue. And even if they're rare, and even if they're not uncommon, like we've had some other speakers say, that's, if your weatherman says, look, it's lightning, but lightning only strikes a person 1 in a million. You still have to pay attention to lightning, and it still can scare people. This is scaring the doctors that will no longer practice, that retire early, that will not move to the state and leave the state after medical school or residency that we otherwise could have here taking care of Georgians.
Thank you.
Thank you.
Thank you, Mr. Chairman. Thanks to the Google machine on my phone, I was able to find a little bit of information about Curry from curry.com. And you were mentioning that there is this bad financial situation, but they're advertising on their website, our financial success allows us to give these member distributions, and those have been since 2008, it says on their website, 51.7 million. And the most recent data available looks to be 2022. It was 2.5 million. Were you aware of that? And if things are so bad, why are we paying out distributions?
I don't debate the fact that Curie and other insurers, again, we've heard evidence are doing well. Our captive in Georgia, who is only in Georgia and covering Georgia physicians, is not doing well.
Well, but they're paying out these distributions.
Not from Georgia.
To everybody.
But
it must not be so bad that they. Well, but it must not be so bad that they can't cover losses here. They don't see losses.
I apologize for interrupting. It's not so bad in North Carolina, maybe, or it's not so bad in Texas or other states that have passed reform. But here in Georgia, our captive is significantly in the hole, and it's not because of investment. It's because of the loss run rate and the expected losses over the next 5 years.
But they're not limiting distributions. I mean, they're giving those to everybody. They're not saying if you're in Georgia, you don't get it, right?
None of our Georgia physicians that are covered are getting any sort of distributions or money back.
None of them?
No.
Okay, we'll check on that. My last question, you inspired, I didn't catch before that you were an emergency room doctor.
Correct.
And emergency room standard of negligence is gross negligence, right?
In certain cases, yes.
That's a pretty good liability protection, right? And there's not any better standard on the doctor side than gross negligence, is there?
You would think, and yet certain cases would bring that into question.
But that's not going to change in this bill, that negligence standard.
That's not addressed in this bill at all, no.
And OBGYNs have that same standard. generally speaking?
OB-GYNs have that same standard if the care is, we'll just kind of say adjacent to someone who presents with an emergency, whether it's in the emergency department or perhaps an L&D unit, again, that is unscheduled care. But
Right.
not every L&D patient would fall
And
under
that's
that.
not going to change under this bill either. We're still providing that pretty good liability protection to doctors, true?
That's correct.
Thank you.
I think Representative Evans, thank you, Mr. Chairman, stole my thunder a little bit about that question. But generally speaking, for a doctor to be sued, they're really not like many other tort feasors in the state of Georgia. They do get certain extra levels of protection. Wouldn't you agree with that?
The ER standard, again, in certain cases, is a different level of protection, yes.
Can you sue a doctor for simple negligence?
For being negligent, yes.
It has to be below the standard of care, correct?
Yes.
Right, and in order to sue a doctor, you have to get another doctor to give the opinion that that doctor performed below the standard of care. Is that also correct?
And I would say that the numbers in these lawsuits and the verdicts that are being given out have created a situation where plaintiffs' attorneys have a cadre of doctors who will say anything for money.
Okay, but I guess the question is, in order for you to even sue a doctor, unlike any other person,
Yes,
like
you have
say-
an affidavit of merit for the lawsuit.
Correct. And so is it just plaintiffs' lawyers who are using experts that are, or is this like is there data to support that plaintiffs' lawyers are using, I guess, experts that are not credible at a higher rate than defense lawyers? You seem to poo-poo another doctor's opinion.
Well, I've read a lot of affidavits, so that's all I can tell you about that.
Okay. Thank you.
All right, you have no further questions?
Thank you.
Thank you. All right, that's the last of our witnesses. And so that will conclude tonight's hearing. And then once I make a decision about what we're doing next, I will let everybody know. Until then, everyone have a good evening.